Wi-Fi alla. You are using that device, correct?
ಇಲ್ಲ ಡಾಟಾ ಆನ್ ಇದಲ್ಲ ಸರ್.
ಲೈಟ್ ಬಂದ್ಬಿಟ್ರೆ ಅದರಲ್ಲಿ ಏನು ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ ಅಂತ ಸರ್. ಟೋಟಲ್ 12 ಇಂದ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಸರ್? ಸರ್ ಸ್ಟಾರ್ಟ್ ಸರ್.
ಸರಿ ಇದೆ ಸರಿ ಇದೆ ಸರಿ.
ಓಕೆ ಸರ್, ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಆಮೇಲೆ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 9 ಅಲ್ಲಿ 2 ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಇದೆ.
ಹಾ,
5141 5143
39 ಲಿಸ್ಟ್ ನಂಬರ್ 239 ಬರೀ ಇಲ್ಲಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ ಯಾವ ಲಿಸ್ಟ್ ಸರ್?
9
ಸೆಕೆಂಡ್ ಲಿಸ್ಟಾ?
ಹೌದು, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್.
ಹಾ, ಹೇಳಿ ಸರ್.
5141
5141
20
ಆಮೇಲೆ
5143/20
5143/20 ಆಮೇಲೆ
ಇದು ಎರಡು ಅದ್ರ ಜೊತೆ ಬರೆದಿಟ್ಕೊಳ್ಳಿ, ಹೇಳ್ತೇನೆ.
ಹಾ, ಆಯ್ತು ಆಯ್ತು, ತಾವ್ ಹೇಳಿ ಸರ್. ಹೆಬ್ಬಳ್ಳಿ ಅವರೇ ಸರ್, ಮೈಕ್ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್. ಮೈಕ್ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್.
ಒಂದು ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು ಅದಕ್ಕೆ.
ಹಾ, ಸರಿ ಸರ್. ಅಲ್ಲ, ಸಾಹೇಬರು ಬಂದ್ಮೇಲೆ ಇದ್ ಮಾಡಿ, ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ, ಅದಕ್ಕೋಸ್ಕರ. ಓಕೆ ಸರ್, ಓಕೆ. ನಮ್ದಂತ ಅವ್ರದ್ದು ಬಂದು ಮಾಡಿದ್ದೀರಾ? posting. ಇನ್ನು ಪಾಪ ಸರಿ ಹೋಗಿಲ್ಲ ಪಾಪ ನೆನ್ನೆ ಹೇಳ್ತಾ ಇದ್ದೆ.
ಇಲ್ಲ ಕೇಳ್ರಿ ಅವ್ರಿಗೆ.
ಮುನ್ರಾಜ್ ಕೋರ್ಟ್ ಆಫೀಸರ್
ಸರ್ ಹೇಳಿ.
ಆ ಮುನ್ರಾಜ್ ಅಡ್ವೊಕೇಟ್ ಅಲ್ಲ ನೋಡ್ರಿ.
ಯಾರಂದ್ರಿ? ಯಾರು?
ಮುನಿರಾಜ್.
ಇಲ್ಲ ಸರ್, ಮುನ್ರಾಜು ಯಾರಾದ್ರು ಇದ್ದೀರಾ? ಇಲ್ಲ ಸರ್, ಇಲ್ಲ ಸರ್.
ಇಲ್ವಾ? ರೈಟ್ ರೈಟ್.
ಇಲ್ಲ ಸರ್, ಇಲ್ಲ.
ಆಯ್ತು.
ಸರಿ ಮಾಡ್ಬಿಡಪ್ಪ. Page wise adjournment, list number 2, page number 1, serial number 1 to 3, page number 2, serial number 4 to 9.
ಸೀರಿಯಲ್ ನಂಬರ್ 9 ಮೈ ಲಾರ್ಡ್, ಸೀರಿಯಲ್ ನಂಬರ್ 9, ಸೀರಿಯಲ್ ನಂಬರ್ 9. ವೆಂಕಟಪತಿ ಅವರಿಗೆ ಡಿಸೆಂಬರ್ 5 ಆಗದಿಲ್ಲ ಅಂತೆ. ಮತ್ತೆ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ 2 ಇದೆ. ನಾನು ಕೋರ್ಟ್ ಆಫೀಸರಿಗೆ ಕೊಟ್ಟಿದ್ದೇನೆ. It may be
Yes.
taken up after 5 and 7 or 8. That
Yes. At the request of counsel for the parties to release this matter along with so and so after 2 weeks.
5141, 5143.
Number 3, serial number 10 to 16. Number 4, serial number 17 to 21. Number 5, serial number 22 to 24.
24. At the request of counsel for exponent number 1. Release this matter after 2 weeks.
Page number 6, serial number 25 to 30.
Yes. The request of counsel for respondent number 2. Release this matter. We will condone the delay. Delay of 159 days in filing an appeal is condoned. IA 1 of 2020 is allowed, not entitled for the interest. Yes.
Page number 7, serial number 31 to 37. Page number 8, serial number 38 to 40. Page number 9, serial number 41 to 47.
Yes.
And it may be called on 28th, my lord. A connected WP yesterday or it was posted, your lordship may recollect.
Yes.
And judge is about recalling the order. So your lordship should post along with this review petition. It may be
Yes,
called on 28th, my lord.
Yes. Serial number 39. Release this matter on 28th.
My lord, serial number
Much.
46.
One nimsha, sir, one nimsha.
43. Yes, office is directed to secure original records from the criminal.
46.
My lord, serial number 46. For personal inconvenience, short accommodations.
You are appearing for?
Appear for applicant. Appellant, sir.
At the request of counsel for the appellant, release this matter after 2 weeks. Yes.
Page number 10, serial number 48 to 55.
Yes. I will inform other side. Yes, at the request of counsel for. Actually, Aurena is not well. Yes.
Page number 11, serial number 56 to 61.
My lord, serial number 60, my lord.
Yes.
Kindly have it next week, my lord, 60.
Yes. D. Vijay Kumar.
I'll inform, my lord.
You inform.
I'll
Yes.
inform.
At the request of counsel for appellant, release this matter next week.
Macho.
Page number 12, serial number 62 to 66.
Serial number 66, my lord.
Yes.
A short accommodation, my lord.
Yes, at the request of parties, release this matter for 2 weeks.
63 also.
Yes.
I have to appellate consumer. But I will inform the other side not by email message.
Yes.
29th or 30th.
Narayan Rao,
I will inform his colleague.
Ravi Shankar, he is appearing because Wakalat is not filed.
I
2011.
got him twice, he is not received the phone call. That's why I sent a message.
Yes, at the request
You
of
can call it
counsel
on
for
29th or 30th.
release this matter next week.
Page number 13, serial number 67 and 68. List number 1, hearing interlocutory application matter, serial number 1 to 13.
Yes.
Admission matter.
Notice all this matter along with us once. File memo in that office. Yes.
Admission matter, serial number 14 to 23.
Notice.
List number 2, for order, serial number 1. EI Sanmati.
Yes. Ready? Ready, Mr. Owner has not challenged cross appeal and he will make a pay and recover. That is the only, where is that discussion, Mr.? Allah, liability. Issue number 5. Payment of compensation, it is not recorded, it is the writer of the respondent. Allah. Issue number 5 in respect of liability. 7. Owner of offending motor vehicles respondent insurance company is on the records that the accident took place on insurance company is valid from. Respondent number 2, owner. Yes, what is the date of the accident? 2015. What was his age? Huh? What is the income? Yes. What is your claim? What was he doing? Criminal ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? Yes.
As of dependence, totally
3,25,000. Dependency comes to, no, they have calculated page 21. 18 multiplier tandidare. What is that income they have taken? Yes. What is your claim? 10,000. What was he doing anything as a student? What is your evidence? Huh? Flower business. What was he studying? Yes. 2015. No, see, 17 and 18 years, if they are working or you are earning along with the study, Supreme Court has considered that. Yes, 17 years, they will, therefore, even that multiplier also, it starts from 15 to 20, 21 to 25, 18. Yes, they may earn along with that district. That is all there in that rural side. They have taken that national income. That then ಅಲ್ಲಿ liability shift ಮಾಡಕ್ ಬರಲ್ಲ. Yes. See, Gurre Prasad Learned Council appearing for. Yes, you can. Appearing for the claimant has contended that at the time of the accident, deceased was aged about 17 years. He was studying 17 years on maybe degree na. You see. What was this? You see, he was student and he was also doing flower business and he was running and he was earning 10,000 per month. The tribunal has assessed notional income of the deceased as 15,000 per annum is on lower side. Hence he sought for ಇದು ತಾಂಡಿದಾರ Peter Prospects ಕೊಟ್ಟಿಲ್ಲ. He further contended that in view of judgment of apex court in case of Pranay Sethi, 40% of the income of the deceased has to be added for future prospects. Lastly, he has contended that the claimants are entitled 44,000 each in view of judgment of apex court in case of Medma. In respect of liability, he has contended that tribunal has exonerated that insurance company on the ground that insured has violated the policy condition. On the ground that the driver of the offending vehicle was not having valid and effective driving license. He further contended that since the claimants are third party, in view of judgment of apex court in case of Swan Singh and Pappu, the insurance company is liable to pay that compensation in first instance to the claimants with liberty to recover from owner of offending vehicle. Hence, he sought for allowing that appeal. Per contra, Shri Sanmati, learned counsel appearing for that insurance company has contended that even though claimant has claimed that deceased was student and he was also doing in a flower business and earning 10,000 per month, they have not produced any document to establish the same. Therefore, the tribunal has rightly considered the notional income of the deceased 15,000 per annum. He further contended that since the claimant has failed to establish the income of the deceased, the tribunal rightly has not granted future prospects. Lastly, he has contended that considering that age and avocation of the deceased, the overall compensation awarded by the tribunal is just and reasonable. In respect of liability, he has contended that the insured has violated the policy condition, has allowed the minor who don't have any driving license to allow him to drive that offending vehicle. Hence, the tribunal has rightly exonerated that insurance company. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties, Feroz, judgment and award. It is not in dispute. Srinivas died in road traffic accident occurred on 17/3/2015 due to rash and negligent driving of rider of motorcycle bearing registration number KA06X1984. Even though claimant has claimed that deceased was earning 10,000 per month doing a flower business, they have not produced any document to establish the same. Under the circumstances, the notional income has to be considered as per the guidelines issued by Karnataka Legal Service Authority for the accident. They have not produced any documents. As per the evidence of PW1, they have categorically stated that even though the deceased was a student, he was also doing in a flower business and earning 10,000 per month. Under the circumstances, the notional income has to be considered as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2015, the notional income has to be considered as 9,000. The multiplier applicable to the age group is 18. Since deceased was a bachelor, 50% of the income of the deceased has to be deducted for personal expenses. In view of judgment of apex court in case of Pranay Sethi, 40% of the income of the deceased has to be added for future prospects. Accordingly, loss of dependency has been reassessed as follows.
6,600 at the rate of 40%, 12,600 minus 6,300 at the rate of 50%, 6,300. 6,300 into 12 into 18, 13,60,800.
In addition, 16,500 for loss of estate, 16,500 for funeral expenses. In view of judgment of apex court in case of Magma, the first claimant is entitled. Parents are 1 and 2. He is not entitled. 1 and 2 are entitled 44,000 each for Filial Consortium. With respect of liability, the tribunal has held that the driver of the offending vehicle was not having valid and effective driving license, has exonerated that insurance company from the liability. In view of judgment of apex court, since the claimant is in a third party, in view of judgment of apex court in case of Swan Singh and Pappu, the insurance company, in the first instance, the insurance company has to pay that compensation amount to the claimants with liberty to recover from owner of the offending vehicle. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. Insurance company is directed to deposit entire compensation amount with interest within 6 weeks from date of receipt of copy of this order, with liberty to recover from owner of the offending vehicle. Delay of 60 days is condoned. IA 1 of 2019 is allowed. Notice to R2 is dispensed. Filed in a memo seeking dispensation of notice. R2 is dispensed at the risk of the appellant.
Serial number 2, Ananta Padmanabha GN for appellate.
This court by order dated 1/9/2022 has passed following order. Even today, the office objection is not complied. In view of order dated 1/9/2022, the appeal is dismissed.
R for appellate. P. Shivakumar.
Yes, week's time is granted to do the needful. Yes, same order.
Number 5, Sripad V. Shastri for appellate.
My lord, I am for appellant, my lord. I am ready. Actually, it is on liability as well as quantum. My lord, it is a public service vehicle, that is a auto rickshaw. My lord, by relying upon an unrelated judgments, my lord, tribunal has exonerated the insurance company from payment of compensation on the ground that no extra premium is paid. But my lord, section 147 clause 2 clearly says, my lord, it is the compulsory coverage. So it's a public service vehicle.
Yes.
So companies is required to be held liable in this case, my lord.
Yes, Mr. Yes. Ready? Yes.
May I continue, my lord?
Right. Valid permit as on that day.
ಹೌದು ಪರ್ಮಿಟ್ ಮೇಲೂ ಇದೆ.
ಹೌದು. What has tribunal has exonerated insurance company? What has happened to that owner? Notice is served.
It is found in page number para number 35.
35.
Is a passenger at the time of permit point. Taken the policy passenger carrying liability policy and not comprehensive policy. The liability policy not cover the passenger of the vehicle. The private in case of private car, my lord, it is not compulsory coverage. Extra premium is to be paid. Section 147 clause 2, it is mentioned that, my lord, is the compulsory coverage for a public service vehicle. It's an auto rickshaw.
Auto rickshaw.
Auto rickshaw.
Auto rickshaw passenger is covered, Mr. Auto rickshaw the linear. It is not in a private. They have purchased for a private use.
Passenger at the time of accident and the respondent number 2 has taken the policy of passenger carrying passenger carrying.
Yeah, no, what is that meaning?
It's all basic.
Wait. Passenger carrying liability and passenger karkondu hogodikiradu. Auto itself is so insurance for the auto for an
Policy, act policy. ಅಲ್ಲಿ ಮುಂದೆ ಹೇಳ್ತಾರೆ.
Allah, it is in a liability policy. Ashte act policy ne. See, transport vehicle ige act policies covers that passenger. It is not in a private vehicle to say that for an is it auto is for a private. He has purchased for a private use. That we have to say. If it is for an transport vehicle, then passenger is covered. Yes.
Did I made up some judgments also in this?
Unless auto personal use purchase madidre, then he cannot carry passenger. That we have to, yes, he wants to verify and make submission. Yes. We'll condone the delay.
Control.
Yes, delay of 5
ಫಿಕ್ಸ್
days.
ಮಾಡ್ಬಿಡಿ ಸ್ವಾಮಿ, ಇದು ₹1 ಸಿಕ್ಕಿಲ್ಲ ಅದಕ್ಕಾಗಿ.
Delay of 5 days in filing an appeal is condoned. IA 1 of 2021 is allowed. When do you want, Mr. Just
Monday?
yes, release this matter on 5th. Yes.
Dispensation ಕೂಡ ಬಂದಿದೆ.
Records beka? Yes, in
Call for record.
policy idea ನಿಮ್ಮ ಹತ್ರ. Yes, office in the meantime.
Judgment ಇಲ್ಲ sir. Call for record.
Yes, office is directed to secure original records from the tribunal. That I think.
Number 6, P for appellant, B Pradeep.
Yes. Take the records. Yes. Office is directed to secure original records from the tribunal.
Number 7, Sripad V Shastri for appellant.
But I am for appellant. It's a claimant's appeal only for enhancement, my lord. ಇದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಇದೆ, ಆದ್ರೆ ಇದ್ರೆ ಡಿಸ್ಪೋಸ್ ಮಾಡಬಹುದು, ಯಾಕಂದ್ರೆ ಇದು ಓನ್ಲಿ ಕ್ವಾಂಟಮ್ ಆಗಿದ್ದಕ್ಕ ಮಾಡಬಹುದು ಅನಿಸ್ತಾ ಇದೆ ನನಗೆ.
Yes, Mr. Connected matter is also for a claimant's appeal.
ಓನ್ಲಿ ಫಾರ್ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಅಂತ ದೊಡ್ಡ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಏನು ಆಗೋದಿಲ್ಲ.
This is arising out of which is
601/2019, that is page number 12, para number 17 of the judgment.
yes.
May I continue, my lord?
Yes.
My lord, the accent is of the year 2018.
Yes.
12,500 rupees ತಗೊಳ್ಬೇಕು, 8,000 rupees ತಗೊಂಡಿದ್ದಾರೆ. First point. Second point is 32 years, my lord, a cook and maid servant claims to be earning 15,000. Sustained fracture of both rami, my lord. Both the rami has been fractured. Injury, severe injuries to right thigh, left foot and left hand. It's all grievous. My lord, she was treated, taken treatment at 3 different hospitals. At last, in 4th, the KC General Hospital, I admitted, and open reduction internal fixation was done, my lord. My lord, there is a disability to an extent of 30% limb and 10% to whole body. But as far as the quantification is concerned, my lord, the parents suffering 35,000 for both the rami fracture associated with other fractures. My lord, it seems in a lower side. And the loss of amenities. She underwent one surgery already and required another surgery also. Amenities 25,000. She was aged 32 years. There is a disability to an extent of 30% to limb. Medical expenses ಅವರೇನು ಕೊಟ್ಟಿಲ್ಲ, ಅದರಿಂದ 5,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ಇನ್ಸಿಡೆಂಟಲ್ 3,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ಲಾಸ್ ಆಫ್ ಅರ್ನಿಂಗ್ 8,000 into 3 months ಅಂತ ಮಾಡಿದ್ದಾರೆ. 12,500 into 3 ಆಗ್ಬೇಕು. ಆಮೇಲೆ as far as these future loss major head, that is 8,000 is considered, and 8% disability is considered in the place of 10%.
Yes.
Because doctor is specifically deposed 30% limb and 10% to whole body.
Yes.
It may be not proper to reduce it by 2%. 16 multiplier ಹಾಕಿದ್ದಾರೆ. 1,22,380 ಕೊಟ್ಟಿದ್ದಾರೆ. ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಏನು ಕೊಟ್ಟಿಲ್ಲ, ಬಿಕಾಸ್ ನೋ ಎವಿಡೆನ್ಸ್ ಟು ದಟ್ ಇಫೆಕ್ಟ್. ಡಾಕ್ಟರ್ ಹತ್ರ ಹೇಳ್ಸೇ ಇಲ್ಲ ಇದು. ಆದ್ರೆ ಓಪನ್ ರಿಡಕ್ಷನ್ ಇಂಟರ್ನಲ್ ಫಿಕ್ಸೇಷನ್ ವಾಸ್ ಡನ್, ಇಟ್ ಇಸ್ ಸ್ಟಿಲ್ ಇನ್ ಸಿಟು.
Yes, Mr. Bill.
Percentage of disability is concerned, that can be 10%, 8%.
Yes. Where is that discussion? He was deposed before the criminal petitioner complaint plain judge. She was further stated she was unable to walk normally. After examination, he found. Doctor has examined.
Yes, doctor examined.
He has examined and he found that completely gift of lower limb is around 40 degrees. Yes. Yes.
It's all very complicated fractures, my lord. Rama andre ಒಳಗಡೆ.
8% is correct.
Yes.
12,500.
Yes.
Remaining 8,000 request only.
Yes. Third. What are the injuries, Mr.
My lord, fracture of both the rama and injuries to right thigh, left foot and left hand. It is
Yes.
forthcoming in the judgment, my lord.
How many major injuries were there? Mr.?
ಇದು fracture of both rama is the major injury. Both ಎರಡಕ್ಕೂ ಇದಾಗಿದೆ.
Yes.
1 minute. This is the judgment number 70.
Yes.
But
Yes.
immediately doctor want to treat doctor, even though you have stated that you have to discharge money, immediately she has not been gone daily. She has treated under management.
ಅಂತ ಡಾಕ್ಟರ್ ಹೇಳಿದಾರಾ?
This is the doctor.
Yes. Where you are reading? Yes. I have personally treated the petitioner. I have seen the wound certificate and discharge summary. Hospital further admitted that he has not stated the same in his affidavit, entered the meaning limitations. Further denied that petitioner has no cause of components. Also further denied that order to help the petitioner has assessed the disability of the petitioner. Treated, even though he has stated that he has seen the discharge summary and discharge before this criminal, he has not been undergone. She has not been undergone surgery and she has. It is not doctor said. Tribunal given a
Tribunal
finding.
ಹೇಳಿದ್ದು.
Doctor ಹೇಳಿದಾರಾ ಸರ್ಜರಿ ಆಗಿಲ್ಲ ಅಂತ? She has not been undergone surgery and she has. Yes. 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 Third. See, Shastri, learned counsel appearing for the claimant has contended that due to that accident, the claimant has suffered grievous injury. She has examined the doctor as PW5. In his evidence, he has deposed that the claimant has suffered 30% disability to particular limb, 10% to whole body. The tribunal has assessed whole body disabilities, 8% is on lower side. He further contended that due to the accident, claimant has suffered grievous injury. She has inpatient for a period of 3 days. She has suffered a lot of pain during the treatment. She has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. For contra, Shri Binny, learned counsel appearing for insurance company has contended that even though doctor has deposed that the claimant has suffered 10% whole body disability, he has not a treated doctor. Even in his evidence, he has admitted that the claimant has not undergone any surgery. Considering the same, the tribunal is justifying assessing whole body disabilities 8%. He further contended that considering that evidence of doctor and injury suffered by the claimant, the compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is just and reasonable. Lastly, he has contended that interest awarded by the tribunal, 7% is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. There was judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 18/12/2018 due to rash and negligent driving of driver of car bearing registration number KA02 MH919. Due to the accident, the claimant has suffered the following injury. Dr. Avinash Parsarthi has been examined as PW5. His evidence, he has deposed that the claimant has suffered 30% disability to particular limb and 10% to whole body. Considering that evidence of Dr. PW5 and considering that injury suffered by the claimant, I am of the opinion that whole body disability has to be assessed 10%. Even though claimant has claimed that income
15,000 ಅಂತ claim
Yes.
ಮಾಡಿದ್ದು.
even though claimant has claimed that she was earning 15,000 per month, she has not produced any document to establish the same. Under those circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurring in 2018, the notional income has to be considered as 12,500. At the time of the accident, he was aged about 32 years, sir.
32 years, madam.
32 years.
ಹೌದು.
Multiplier applicable to that age group is 16. Accordingly, loss of future earning has been reassessed as follows.
40,000.
Due to that accident, claimant has suffered the above said injury. He was inpatient for a period of 3 days. She has suffered a lot of pain during the treatment. She has to suffer the disability and unhappiness throughout his life. Considering that evidence of doctor injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 35,000 to 40,000. Loss of immunities 25,000 to 30,000. Loss of income during the later period for 3 months. The compensation awarded by the tribunal for nourishment conveniences has to be enhanced from 3,000 to 8,000. The compensation awarded by the tribunal in the other hand are just and reasonable. Enhanced compensation amount carries 6% interest.
Number 8, but for appellant Ravish Benny.
Yes. Yes. Notice to R1, Learned Counsel for the appellant has filed a memo seeking dispensation of service of notice to R1. Notice to R1 is dispensed. Delay of 108 days in filing an appeal. For the reason stated in the accompanying affidavit, delay of 108 days in filing an appeal is controlled. Yes. Office is directed to secure original records from the tribunal.
The date of judgment actually it is 8th August 2019. But in the first page of the judgment, it was wrongly mentioned as 8th day of July.
You will say anyhow you are securing the records.
Number 9, Arjun. Number 10, Suresh M. Rathore for appellant Shivanya Gowda.
In this case, I IP for the respondent, Mala.
Yes. Yes. Notice to R1 is dispensed. Notice. Yes. Office is direct heard admit.
LCR may be called for.
Yes, yes, you admit. Yes.
Sachin DS for appellant.
Counsel submission regarding the office objection. Non-arraying R4 and R5 before the trial court as a party. Why? No, R4 and R5, they are the party before the tribunal. Here you are making, why? Which is that MSC, Mr. 900. Yes. 900. Claimant is in the shop. Who are the respondents? In case of real respondent. Yes. Submission of learned counsel for the appellant is accepted. Office objection is overruled. Claimant appeal. Notice.
Yes, Basavaraju for appellant.
Yes, Basuraj. This court by order dated 23/9/2022 has granted a week's time to comply that office objection. If the office objections are not complied, the appeal will be dismissed. Even today, the office objection is not complied. In view of order dated 23/9/2022, the appeal is dismissed.
Murthy DL for appellant. Number 13.
ಬೆಳಿಗ್ಗೆ ಒಂದು ಅದಲ್ಲ ನನ್ನ ಅಪಿಯರ್ ಅಂತ ಹಾಕ್ಬಿಟ್ಟು then DL. What below cost title with respect to the R3 of the trial court. So yes, none appear. Release this matter of 2 weeks.
Number 14, Jaganmohan MT for appellant.
Next time is granted to comply the office objection. Non-compliance of the office objection for court order, Mr. There is an order, you have to comply by today. No, that court has granted in a week time. It made clear that if the office objections are not complied, the appeal will be dismissed. There is already an order. Without recalling that, how can I grant, Mr.? Without recalling that order, how can I grant? Pass over by that 130, you comply. And to do that, then you have to file an application for recalling that order. Call this matter next week. I am not granting any time to comply. I will grant. Yes.
Number 15, R. Sridhara for appellant, Geeta Raj.
Yes. Shashidhar, pass over.
Number 16, Pawan Chandra Shetty for appellant, SP Vijayendra.
Yes, Pawan Chandra Shetty, pass over.
Number 17, Nayak Krishna for appellant.
Notice memo is taken on record. Notice to R1 is dispensed at the risk of the appellant. First time R2 is first time left.
Second time, liberty.
V. Samprati is directed to take notice for respondent number 2. Learned counsel for the appellant is directed to serve one setup.
Number 18, B.S. Umesh for appellant.
Mesh, note that cost title with regarding to the deceased claimant is Rajan of who was LRs are not brought on record before trial court. Office note. Yes, Mr.
Rajan died after the disposal. A review petition was filed and LRs were brought on record. A review copy is also filed, my lord. So I have brought the LRs on record, my lord, straight away in the appeal. In the judgment, of course, my lord, Rajan's name reflects.
Why they have not made an amendment?
My lord, it was after the disposal, but before a review was filed, could be filed. A review nalli now directly Rajan and LRs and party martivi. They are made parties now, my lord.
No, that when he has died.
Is completely represented.
When he has died, Mr.
After judgment, my lord.
After judgment.
Before
Yes.
the review petition was filed.
Yes.
So in the review petition, my lord, I brought the LRs on record. And on the basis of review only, I have implemented the LRs, my lord, straight away.
Yes. Submission of learned counsel for the appellant is accepted. Office objects is overruled. Yes.
In the case of fraud, my lord, and my liability is questioned.
No, that, is there any delay?
No, my lord, there is no delay. Otherwise, probably just that matter would have been listed for the corona period. So.
Altre, ನೀವೇನು very distinct, Mr.
I
It is
submit.
your own, it is your own appeal. You have filed an application for delay.
ಹೌದು
Now you are
ಆಮೇಲೆ
saying that there is
ಇಲ್ಲ
no
ಇಲ್ಲ ಅಂತ
delay.
ಹೇಳಿದ್ರು ಆಫೀಸಲ್ಲಿ ಹೇಳಿದ್ರು.
Is it not?
I'll post it next week. I'll also verify and come with the correct position. But I was told that during the corona, limitation was excluded and that is.
No, after that also they said that 2,818 days delay.
Then my lord, I'll deposit the entire amount before this.
Will is this matter day after tomorrow?
Next week, your
Yes, next week.
oblige. Oblige.
Number 19, KL Srinivas for appellate.
Not in the cost title with regarding to non-arriving of R3 before the trial court as a party to this appeal. Yes. Who is R3? No, why you have made the two insurance company as a party there? ಅಲ್ಲ ನೀವು ಮಾಡಿರೋದೇ ಪಾರ್ಟಿ ಇಬ್ಬರನ್ನ. Where is that? Advocate so and so, the respondent number 1 and 2 are jointly liable. Yes, divisional manager Tata ACJ. Yes. Which is that serial number? Yes. Submission of learned counsel for the appellant is accepted. Office objection is overruled. It's a claimant appeal. Notice.
Number 2, Soumya R for appellate.
Yes, Soumya. Hmm. 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 Now, what is that office objection? First. Wait. Challenge case number so and so that petitioner to be made party to this appeal. Appeal to be completely paginated and blank index to be filled. So and so. Petitioner to be made party to this appeal. Which is that claim petition MEC we are challenging now? 1307. 1307 first matter. There are two claimants. Now that so and so. Who is Chandra Kumar? See, Shivana is dead. Who is that Hanumaka? How is it? Hanumaka is the mother. Then Charan Kumar. Why? Where is that degree? One 1307. A petition filed by the petitioner so and so. Where is that para? Yes. No, that is not that, madam. That is that objection. Where it is dismissed. By petition of the petitioner number 2, MEC 1307. Yes. Operator portion of the order idealry. Yella heltiralla. Claim petition of the petitioner number 2 in MEC 1307/20 and MEC 221 as stand dismissed. They are not challenged. Yes. You have made him as in a party. Respondent number 4. Yes. Why? No, Hanumaka, wife of late Shivanna. Not same, madam. The same number, same. See, they have a similar name. They are a different person. ಆಯ್ತ್ರಿ ಹೆಸರು ಒಂದೇ ಬೇರೆ ಬೇರೆ ಪರ್ಸನ್ ಅಂತ ಹೇಳಿ ದೇರ್ ಆರ್ ಎ ಡಿಫರೆಂಟ್ ಪರ್ಸನ್ ಮೇಡಮ್ ಸಿ ದಟ್ ಹನುಮಕ್ಕ ಇಸ್ ದ ವೈಫ್ ಆಫ್ ಲೇಟ್ ಶಿವಣ್ಣ ದಿಸ್ ಹನುಮಕ್ಕ ಇಸ್ ದ ವೈಫ್ ಆಫ್ ಲೇಟ್ ರಂಗಪ್ಪ where yes, respondent number 4. Why she has been made as a respondent? No, that is your claim petition. Why you have made them as a respondent as well as claimant? You have to explain, madam. It is your petition. ಆಯ್ತು ನಿಮ್ ಕ್ಲೈಮ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಮಾಡಿಲ್ವಾ ಅವ್ರನ್ನ ಹನುಮಕ್ಕನ ವೇರ್ ಇಸ್ ದಟ್ ಕ್ಲೈಮ್ ಪಿಟಿಷನ್ then who has made her as a party here? Yes, yes. ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ ಪಿಟಿಷನರ್ ನಂಬರ್ 3 ಮಾಡಿದ್ದೀರಲ್ಲ ಹನುಮಕ್ಕನ you see that who is the claimant number 3, madam. Here Hanumaka is also there in your petition. There are 3 claimants. ಆಯ್ತ್ರಿ now why that Hanumaka has not been made as a claimant here? There are 3 claimants. It is dismissed against 1 claimant. Other 2 claimants are there. You have made only 1 Hanumaka. Where is that other Hanumaka, wife of Shivanna? In that claim petition, there are 3. No, ಆಯ್ತ್ರಿ ನಿಮ್ claim petition ಪ್ರಕಾರನೇ Hanumaka, wife of Shivanna, is also claimant. Now why you are not made her as a claimant here? Yeah, now you verify? Yes, next week. Yes, next week, next month. Yes.
Hearing interview of the application matter, to number 21, AK but for appellant, connected matter, Shivane Gowda.
Yes.
In this case, I appeal for the respondent.
Yes. Serial number?
Sir, 21.
21.
Shipa Shastri.
AK Bhatru Vakalat ಹಾಕಿದ್ದಾರೆ, no objection.
Yes, Mr. What is this? Delay of 6 days in filing an appeal is controlled.
Owner liability matter claim petition has been dismissed. That's the reason they have preferred appeal.
Yes. Owner appeal.
One is owner appeal, another one is claimant appeal.
Yes. Wait, first I will come to that one by one. See, in your case, 6 days delay is condoned. permission of production of documents ಏನ್ರಿ ಅದು?
That they have not served the copy to us, my lord.
Copy ಕೊಡ್ರಿ ಅವರಿಗೆ. He has to see whether that is a correct documents or
there.
not. In 21.1 ಅಲ್ಲಿ who is R1, Mr. You will take notice, Mr. But
Owner of the vehicle.
yes, R1 Shri AK Bhatt is directed to, is undertaken to appear for respondent number 1. Office is directed to show his name. Yes, you saw that copy. In the meantime, office is directed to secure original record. Nimta copy ಕೊಡ್ರಿ ಅವರಿಗೆ.
Macho.
Shankaraj paper appellant FS Dabali.
Yes, Mr. Dhawan. Yes. Where is your application, Mr.? For the judgment on sound check, since after the accident I could not able to do my to-do work and my earning capacity has become completely diminished. I post my local advocate month of 2019. Due to the judgment, my local advocate has noticed that university has no or any just compensation dispute. Yes, yes, that they have not disputed. Advocate Bangalore, he is hereby denied the false imaginary in the absence of any material produced substance that per case but put shown. Yes. Yes. Tale. ಅಲ್ಲ ಅದ್ ಮೆರಿಟ್ ಮೇಲೆ ಆಮೇಲೆ ಬರೋಣ. First we'll see that delay. Yes. IA 1 of 2019 is filed for condonation of delay of 718 days in filing an appeal. IA 1 of 2009 filed for condonation of delay. Respondent has filed an objection. Peruse that affidavit filed along with that application. For the reason stated in that accompanying affidavit, delay of 718 days in filing an appeal is condoned. IA 1 of 2019 is allowed subject to condition. Appellant is not entitled for the interest for a period of 718 days. Yes. Office is directed to secure original records from the tribunal.
Number 23, B. Pradeep for appellant, connected matter with Chivanegowda, Parshuram R. Attak Yard.
The notice to R3, A and B and 4 maybe in my
Yes.
case.
Notice to
Notice to R3, A and B and 4. In appeal number 1264 of 19.
ಸರ್ವಾಗಿದೆಯಲ್ಲ ಎಲ್ಲರಿಗೂ.
ಇಲ್ಲ ಸರ್ವಾಗಿದೆ. ನೋಟಿಸ್ ಟು ಬಿ ಆರ್ಡರ್ ಅಂತ
ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಿಲ್ವಾ? ಡಿಪಾಸಿಟರ್ಸ್ ಅಮೌಂಟ್ 5 so and so 23.1 ಅಲ್ಲ?
ಹೌದು.
For permission to be withdrawn, Pradeep notice to be order for respondent number 3, A and B and C. Who is that respondent number 3?
Respondent number 3 is the claimant mala. Respondent number 1.
1 ಗೆ ಏನಾಗಿದೆ?
Respondent number is my insured my lord.
Respondent number 1 is your insured.
ಹೌದು.
ನೋಟಿಸ್ ಹೋಗಿದ್ಯಾ ಅವರಿಗೆ?
ಹೋಗಿಲ್ಲ, ಅದಕ್ಕೆ ಆರ್ಡರ್ ಆಗಿಲ್ಲ.
ಯಾರು ರೆಪ್ರೆಸೆಂಟ್ ಆಗಿ?
Parshuram Attak.
R1 ಅದು R1 and 2 R1 and 2 ಆಗಿದೆ. 3 ನೋಟಿಸ್ ಆಗಬೇಕು. ಎಸ್, ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 3, A and B and 4. 5 ನೀವು ಅಪೇರ್ ಆಗ್ತೀರಲ್ಲ. ಎಸ್. ವಾಟ್ ಅಬೌಟ್ ಇನ್ ಯುವರ್ ಕೇಸ್ ಮಿಸ್ಟರ್ ಪ್ರದೀಪ್? Permission to withdraw that amount, they have not representing. Yes. 23.1 ಅಲ್ಲಿ issue notice to respondent number 3, A, B and respondent number 4. Yes.
Okay.
Number 24 adjourned. Number 25, Number KM for appellant, B. Pradeep.
21 days delay is condoned. IA 1 of 20 is allowed. Accepting the wakalat filed by Sri B. Pradeep. Yes. Ready? Yes. Global Madida. Yen injury apa? Yen eradidia. Yen 5 lakhs 74,000. Alla medical expenses 5 lakhs. Alla, what you are saying that 20 both are agreed. That's what you said. I said that the compensation is awarded itself is 20,000. What is this? Yes. Yes. Shri. Yes, notice to R1 is dispensed. Yes. Delay of 81 days condoned. So and so learned counsel appearing for the claimant has contended that due to that accident, claimant has suffered the following injury. He was inpatient for a period of 8 days. He has suffered a lot of pain during the treatment. He has suffered this disability and unhappiness throughout his life. The compensation awarded by the tribunal, the overall compensation awarded by the tribunal, 5,74,000 is on lower side. Hence, he sought for enhancement of compensation. Per contra, B. Pradeep, learned counsel appearing for insurance company has contended that considering that evidence of doctor and injury suffered by the claimant, tribunal has granted a just and reasonable compensation. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. There was judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 15/5/2018 due to rash and negligent driving of driver of car bearing registration number KA50P5955. Due to that accident, claimant has suffered the following injury. He was inpatient for a period of 8 days. He has suffered a lot of pain during the treatment. He has suffered this disability and unhappiness throughout his life. Considering that evidence of doctor injury suffered by the claimant, I am of the opinion that in addition to the compensation awarded by the tribunal, 25,000 has been awarded with 6% interest. Accordingly, the appeal is disposed of.
Nagaraja SR for appellant, United India.
United India United India Insurance Company. With Shankar Reddy. Yes. Notice to R2 is served. There is a delay of 1,237 days in filing an appeal. Notice to respondent is served. No objection is filed. For the reason stated in that accompanying affidavit, delay of 1,237 days in filing an appeal is condoned. IA 1 of 2020 is allowed subject to condition. Appellant is not entitled for the interest for a period of 1,237 days. Since respondent number 2 is served, the Shankar Reddy is directed to take notice. Learned counsel for the appellant is directed to serve one set of copies on Shankar Reddy.
25 notice not ordered, so acceptance.
No, but the disposal ali, wakalat filed by B. Pradeep for respondent number 2 is accepted. Yes.
Number 27, government advocate for appellant, municipality, Rajshekar K.
Yes. Where is that government advocate? Pass, pass or let them appear first. Yes.
Number 28, Venkatesh Kamath, we are for appellant.
Yes. Delay of IA 1 of 2021 is dismissed as not trust. Yes. Insurance company appeal. On what ground you are challenging?
Yearly bill as on the date of act. And the additional premium in that,
For what?
loader and
The loader and unloader goods automation. Delay in Ilva. Yes. Heard. You notice. Day of judgment and award dated 27th November 2020. Passed by MEACT Kundapura in MEC 143 of 2015, subject to deposit of 50% of the award amount with interest before the tribunal within 4 weeks from before this court within 4 weeks from today.
Number 29, adjourned. Number 13, Nishit Kumar Shetty for appellant.
29 urgent, my lord.
Yes. 29, somebody has taken time, madam. No, delay is controlled.
But LCR is required, already called on in 3/2/2022.
Yes, madam.
Number 30, Nishit Kumar Shetty.
Permission to prosecute as a legal heirs of the appellant. Why? Climate is died. When? (6/11) after the judgment. After the judgment is a case of injury. Now, what is who is that appellant? How he is related? How is related to that climate, mister?
Is the wife of the.
Yaro? No, that since represented by his legal heir, wife, yes. So notice on IA. Yes, serial number? Serial number 30. Yes, issue notice on main as well as IA. Yes.
Number 31, FS Dabali for appellant.
IA, but I issue notice on command. Yes. IA 1 of 2021 is dismissed as not trust. Yes, Mr. Dabali, on what ground you are challenged? No, your case is that he was a negligent. Yes. Or issue notice. Day of judgment and award dated 10th February 2021, passed by MEACT Shimoga in MEC 918 of 2018, subject to deposit of 50% of the award amount within before tribunal within 4 weeks. 8 weeks. Yes, 8 weeks before the tribunal. First respondent, fourth respondent memo filed for dispensation. Notice to fourth respondent is dispensed. Other respondent emergent notice.
Number 32, Pratik Kesi for appellant.
IA 1 of 2022 is dismissed as not trust. Yes, madam. Climate. Who is that appellant? Appellant is the climate. Yes, issue notice. Yes, Yes, Mr. Yeah, on what ground you are challenging, Mr.? You don't want stay. ಮತ್ತೆ ಏನ್ ಗ್ರೌಂಡ್ ಮೇಲೆ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು? Determined not payable, the opponent insured has taken a specific defense effect that license said by the driver of the lorry was not valid, subsisting and driver in any event can't be considered as a daily license person to drive the lorry which was carrying hazardous goods. Stay quoted. Yes. Or issue notice. Stay up. Which is that MSC, Mr. 616. 616. 616. Yes. Judgment and award dated 31st December 2019 passed by MACT Piriyapatna in MSC 616 of 2015. Subject to deposit entire compensation amount. ಯಾವ್ದ್ರಲ್ಲಿ ಇಲ್ಲ ಡಿಲೇ ಇರೋದ್ರಿಂದ ಐ ಹ್ಯಾವ್ ನಾಟ್ ಡನ್ ಇಟ್. ಅದರಲ್ಲಿ ಡಿಲೇ ಇರ್ಲಿಲ್ವಾ? ಎಂಟೈರ್ ಅಮೌಂಟ್ ಡಿಲೇ ಇರೋದ್ರಿಂದ ಐ ಸೆಡ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್. ಎಸ್, entire amount before this court within 4 weeks.
34 Krishnaswamy and for appellant.
Same. Yes, in MSC 615. Same other.
Number 35 Krishna Kishore, yes.
Yes, Mr. Liability. Yes, heard issue notice. Stay of judgment and award, which is that MSC 943 passed by University Kundapura, subject to deposit entire compensation amount with interest before this court within 4 weeks. Which is that MSC 944 of 2019. 50% all full entire amount. Yes.
37 Shivananda.
Before this court within 4 weeks. Yes.
for the appellant, madam. The liability challenge ಮಾಡಿದ್ವಿ. Liability only policy ಇದು. 104 days delay ಇದೆ. I'll deposit the entire amount before this court.
Yes. Stay of judgment and award dated. What is the date? 29th October 2020 passed by MACT Ennarpura in MEC 276 of 2019, subject to deposit the entire compensation amount with interest before this court within 4 weeks from today.
Janardhan Reddy for appellant.
My lordship, you are questioning the liability, my lordship. As on the date of there was no policy, my lordship. Connected cases already deposit stay ಮಾಡಿದೆ ಸಂಬಂಧ.
Yes, notice. Stay of judgment and award dated 25th March 2022 passed by MACT Bangalore in MEC 3357 of 2017, subject to deposit the entire compensation amount with interest within 4 weeks.
Before the High Court, my lordship.
Before this court, yes.
Yes, sir.
This matter has been called along with that matter on 28. Yes, on that day we'll decide. If they want to recall, we'll recall everything.
Matter number 40 Girish V. Valadare for appellant. Connected matter MS Sriram, Dan Srinivasa, Vegetable judges.
Yes. You are appearing for? Yes. Sriram Elidra. Huh? No, that's what that our MS Srinivas avರಿಗೆ our colleague ಯಾರು ಬರ್ತಿಲ್ಲ ಅವ್ರ ತಾನೆ. Tipesh, where is he? Get him. Pastor will get him. Yes.
Number 41 Mo Mahesh for appellant. Harish HV 41.
Yes, 41. Pastor. Huh? Yes, at the request of respondent number 1, release this matter next week.
Number 42, MD Chandrachud for appellant, CR Ravi Shankar.
Chandrachud. Unappear, release this matter of 2 weeks.
Number 43, adjourn. Number 44, Nagaraja K for appellant.
Please, my lord, I appeal for the appellant KSRTC.
Yes, what is-
This appeal is filed by the KSRTC on the ground of quantum of compensation being excessive.
Yes.
May I take your lordship's kind attention to the synopsis so that, my lord, I can briefly explain.
Yes, yes.
My lord, the date of accident is 2013 to 2016.
Yes.
Claimant, my lord, filed claim petition in MVC number 125 2018 towards
Yes.
the injuries suffered due to the accident. As per judgment dated 11/12/2018, the tribunal awarded compensation of rupees 4,60,000 within. I am at the point of, my lord, with regard to loss of future income, because
Yes.
my lord, he was working on contract basis at BEML. My lord, he has not either resigned or, my lord, his salary has not been reduced. Nowhere, my lord, he has stated in the either in the claim petition or in the affidavit or in the evidence. Therefore, my lord, I am on this point. And, my lord, with regard to the future medical expenses,
And earning 10,000 per month. Yes, he is not in a permanent employee, contract employee, termination and one.
Either he has to resign or, my lord, I don't know whether he is continued in the job. Even though
What is his evidence?
nothing is there. Nothing is there, my lord.
He has that is evidence. PW1. Pass over, let him come. Let us see if we have evidence. We'll see whether he said that I am not working. Pass over, Nagraj. Let us see. Let him come. Yes.
45, Kamala DK for appellant, K. Kishore Kumar Reddy.
Yes, pass over.
Number 46, adjourn. Number 47, R. Ritijara for appellant, B. Pradeep.
40? 47. Yes, at the request of counsel for respondent number 2, release this matter of 2 weeks.
Number 48, Prakash, MH for appellant, O. Mahesh.
Yes, Prakash. Oh, Mahesh, pass over, Prakash.
Number 49, Chandrasekhara B. for appellant, Lalita PM.
Yes. Yes. 40. Only income. Yes. Only income. Now, what is the date of the accident? Yes. Oh, it's a case of death. Injury. Yes. 2017. 17. Claimed income is 15,000. Is a tribunal or 8,000. 2017 and 11,000. Sorry, career case.
Serial number 49, Chandrasekhara B for appellant, Lalita PM. Serial number 49.
Yes, where is that?
Lalita PM.
What is the disability assessed by the tribunal? 14%. Tandidarala? 14%. Yes. How many days?
Number 49, Your Worship.
Yes, yes.
आप ये responded to Your Worship.
Yes, yes. 20 days. Inpatient. Pain and suffering. 40 loss of future earning ಕೊಟ್ಟಿದ್ದಾರೆ. Conveniences, nourishment, food ಕೊಟ್ಟಿದ್ದಾರೆ. Amenities ಕೊಟ್ಟಿಲ್ಲ. Later period income ಅಷ್ಟೇ. ಡಾಕ್ಟರ್ ಎಷ್ಟು ಹೇಳಿದ್ದಾರೆ? Just 22 hours convenience, nourishment ಎಷ್ಟು ದುಡ್ಡು ಹೇಳಿದಾರ್ರಿ? ಅಲ್ರಿ ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸ್ ಅಷ್ಟೇ. Yes, madam.
Seal number 49, Your Lordship, it's a death case.
Injury, madam. It's a case of injury. What you want to? What is your submission regarding that?
62,
Compensation is.
Your Lordship, 6202 of 2018, Your Lordship, the case number.
7394 of 2019, madam.
ಇದು ಅಲ್ಲ ಬಿಡಿ, ಅಲ್ಲ, sorry.
Chandrasekhara B, Lalita PM.
Yes, appear for the appellant in this case, Your Lordship. Your Lordship, one date may be given, Your Lordship.
No,
Please,
nothing
I
is
need
there. You
I know.
just hear me. You just hear me. I will dictate. Yes.
A reasonable award may be passed, Your Lordship.
No, that your name is Lalita PM.
Yes, Your Lordship, yes.
You are appearing for the corporation.
Yes, Your Lordship.
Yes, just you hear me. Yes. Tell. Shri Chandrasekhara B, Learned Council appearing for the claimant has contended that at the time of the accident, she was earning 15,000 per month. The tribunal has assessed notional income of the claimant as 8,000 per month is on lower side. He further contended that due to the accident, claimant has suffered grievous injury. She was inpatient for a period of 20 days. She has suffered lot of pain during the treatment. She has to suffer the disability and unhappiness throughout his life. The compensation awarded by the tribunal, pain and suffering, other incidental expenses is on lower side. The tribunal has failed to grant any compensation for loss of amenities and loss of income during the later period. Hence, he sought for enhancement of compensation. For contra, Lalita PM, Learned Council appearing for the corporation has contended that even though claimant has claimed that she was earning 15,000 per month, she has not produced any document to establish the same. Therefore, tribunal has rightly assessed the notional income of the claimant as 8,000 per month. She further contended that considering that evidence of doctor and injury suffered by the claimant, and considering the wound certificate and discharge summary, the compensation awarded by the tribunal, pain and suffering and other incidental expenses is just and reasonable. Hence, she sought for dismissal of the appeal. Heard the Learned Council for the parties arose judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 27/4/2017 due to rash and negligent driving of driver of bus bearing registration number A42F249. Due to the accident, claimant has suffered the following injury. Considering that evidence of doctor, the tribunal has rightly assessed whole body disability is 14%. Even though claimant has claimed that she was earning 15,000 per month, she has not produced any document to establish the same. Other circumstances, notional income has to be assessed as per the guidelines. For the accident occurred in 2017, notional income has to be considered as 11,000. At the time of the accident, she was aged about 55 years. The multiplier applicable to the age group is 11. Accordingly, loss of future earning has been reassessed as follows. Due to that accident, claimant has suffered the aforesaid injury. She was inpatient for a period of 20 days. She has suffered lot of pain during the treatment. She has to suffer this disability and unhappiness throughout his life, considering that evidence of doctor and injuries suffered by the claimant. I'm of the opinion that the claimant is entitled 35,000 for loss of immunities, loss of income during the later period for 2 months. The compensation awarded by the tribunal on the other hand are just and reasonable. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows.
Appellant B.B. Raju.
Yes, Mr. Raj. Yes. Serial number 50. Yes. Why? What was he? $400 per day. Where is the discussion of the tribunal? Yes. ಏನ್ PPA ಅಂದ್ರೆ physical impairment ಅಷ್ಟೇ. No, that is 8 point which is assessed for a particular limb and it applies to whole body. Particular limb ಅಂತ ಹೇಳಿದ್ರು ನಿಮಗೆ 3% ಬರ್ತದೆ. Whole body it will comes to 3%. Tribunal ಏನ್ ಮಾಡಿದಾರೆ ಅದಕ್ಕೆ? They have not granted any compensation. Yes. What is the date of tax day? Yes. ಎಷ್ಟು ದಿನ ಹಾಸ್ಪಿಟಲ್ ಇದ್ರಿ? Expenses toward the treatment hospital miscellaneous 2,000 ಕೊಟ್ಟಿದ್ದಾರೆ. Nourishment attendance 2,000. Earning during the period of treatment 5,000 ಕೊಟ್ಟಿದ್ದಾರೆ. 7 days ಇದ್ರಾ? Pain and suffering 40 ಕೊಟ್ಟಿದ್ದಾರೆ. Loss of immunity 2,000. 7%. Yes, Mr. Jagdish. Unmute ಮಾಡಿ. ಪೇನ್ ರಿಕವರಿ ಮಾಡಿದಾರಾ? ಏನ್ ಮಾಡಿ? ಯಾರ ಮೇಲೆ? Then owner is served.
ಮೈಕ್ ಮ್ಯೂಟ್ ಆಗಿದೆ ಸರ್, ಮೈಕ್ ಮ್ಯೂಟ್ ಆಗಿದೆ.
No, now it is served and represented here.
ಮೈಕ್ ಮ್ಯೂಟ್ ಆಗಿದೆ ಸರ್, ಜಗದೀಶ್ ಅವರೇ.
Where is that discussion regarding the disability? Para 39 ಓದಿ. No, then it is you are traveling as an unauthorized passenger, then insurance company is not liable. Now that latest pain recovery is also can't be. Now you have to argue that you are not an unauthorized this thing. Then you will secure the records, Mr. Bandida. Then you are ready, Mr. Raja.
My lord, next week, my lord. Sorry, my lord. ನಾನು physical ಬರ್ತೀನಿ ಸಮಯ due to inconvenience ನಾನು ಇವತ್ತು ಬರಕ್ಕೆ ಇದಾಗಿಲ್ಲ.
Yes, now you have to convince the court that you are traveling as a loader. Yes.
Sorry, my lord.
Yes, yes.
Due to ಇದರಿಂದ ಇದಾಗಿಲ್ಲ.
Yes, at the request of parties, release this matter of 2 weeks.
As per appellant.
My lord, I appear for the appellant. Insurance company's appeal, my lord.
Yes.
Sought for stay in excess of 50%, my lord. 50% I will deposit.
On what ground you are challenging?
My lord, the one Abdul Samad died in an accident. Wife, he was aged 65 years. Wife, first claimant, also died during the pendency of the petition. But the 50% should have been deducted. Tribunal has taken the children also into account and deducted. Second aspect is 6,000 rupees salary should have been taken.
Yes.
And yes.
To notice day of judgment and award dated 23rd August 2019 passed by MECT Chamarajanagar in MEC 196 of 2011 subject to appellant deposit 50% of the award amount with interest before the tribunal within 4 weeks from today.
My lord, notice to R5 owner may be dispensed.
Memo kodi.
I'll file a memo.
Yes, you file it memo, then we'll discuss. Yes. No dispute regarding the liability. Yes. Then you are. $2,000? Yes. 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 Yes, where is that discussion? Is there any dispute? Yes. What is the income assessed by the tribunal? "34 days hospitalized, huh? Income of disability towards medical expenses ಕೊಟ್ಟಿದ್ದಾರೆ, conveyance, attendance service, pain and suffering ಕೊಟ್ಟಿದ್ದಾರೆ, fracture medical expenses, future medical expenses, amenities ಕೊಟ್ಟಿಲ್ಲ. Later period, what about that interest? Yes, that's all. Three. Status N. The net council appearing for climate has contended that as on the date of the accident, he was earning 300 rupees per day. Tribunal has assessed notional income of the claimant as 6,000 per day per month is on lower side. Contended that due to that accident, claimant has suffered grievous injury, was inpatient for a period of 34 days. He has suffered a lot of pain during the treatment. He had suffered with disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and suffering, other incidental expenses is on lower side. The tribunal has failed to grant any compensation for loss of immunities and loss of income during the later period. Hence, he sought for enhancement of compensation. For contra, B. Pradeep, Learned Counsel appearing for insurance company has contended that even though claimant has claimed that he was earning 400 per day, 300 per day, he has not produced any document to establish the same. In other circumstances, the tribunal is rightly assessed the notional income of the claimant as 6,000 per month. Further contended that considering that evidence of doctor and injury suffered by the claimant, the overall compensation awarded by the tribunal is just and reasonable. Lastly, he has contended that interest awarded by the tribunal 7.5% is on higher side. Hence, he sought for dismissal of the appeal. Heard the Learned Counsel for the parties, Perot's judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 7/2/2014 due to rash and negligent driving of driver of auto rickshaw bearing registration number KA06B5054. Even though claimant has claimed that he was earning 300 per day, he has not produced any document to establish the same. In other circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2014, the notional income has to be considered as 8,500. Accordingly, monthly income of the claimant has to be assessed as 8,500 per month. The tribunal has rightly assessed whole body disabilities 6%. At the time of the accident, he was aged about 45 years. The multiplier applicable to that age group is 14. Accordingly, loss of future earning has been reassessed as follows.
85,680.
To that extent, claimant has suffered grievous injury. He was inpatient for a period of 34 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor injury suffered by the claimant, I am of the opinion that the claimant is entitled compensation for loss of immunities 40,000 rupees and loss of income during the later period for 3 months. The compensation awarded by the tribunal in the other hand are just and reasonable. Yes, our conveyances has to be enhanced from 10,000 to 20,000. Other hand, compensation awarded by the tribunal is just and reasonable. The enhanced compensation amount carries 6% interest. In view of order dated 13/10/2022, claimant is not entitled for the interest for a period of 483 days. Yes. Yes, B. Pradeep is permitted to file an wakalat within 4 weeks from today. Yes. Yes. No. If you are ready in this matter, I can permit it to file an wakalat. But if you want to see that other, I will grant time if you are not ready. Yes, he is not ready. Let it. Yes. Bharat. Yes, at the request of respondent number 2, release this matter after 2 weeks. Yes.
Number 54, Shivakumar P for appellant, Shankar Gaudji.
Yes, who is shift? Yes. Learned counsel for respondent submits that his appeal may be called along with that so and so. Yes.
Number 55 adjourned. Number 56 Spurti Agreement for appellant. Number 1.
Now, petitioner number. No, that it's a case of death. Who are the claimants? Parents. Bachelor. Mother is dead. Father is dead. Mother is the only loss. Now, what is that office objection? Reporting for death of R2 when he. Death of PW2 before the trial court and appellant is the sole LRs of deceased so and so. Submission of learned counsel for the appellant.
Office objection.
Office objection ilwa? Why you have filed any memo? There is no office objection. Yes, memo is dismissed as not pressed. Yes, we claim it. No, notice, let the notice go. Notice is out. Order agilala. Agidya? No. Division bench. Division bench. Office has raised the objection with regard to the maintainability of learned counsel for appellant submit that appeal is restricted to 15 lakhs. Submission placed on the New York office objection raised and registered counsel appellant restricted the appeal 15 lakhs. Already notice agila bari post before anta agide ashte. Notice. Yes, now that will go. That they will not send notice unless we ordered. Yes.
Number 57 Banu HM for appellant.
Yes, madam. Insurance was not there. The injury na petitioner was traveling as a pillion rider scooter bearing. It is written by our friend Akshita. When they reached near Modi zone, so at that time, one she motorcycle bearing Bajaj Discovery ridden by the rider came in rash and negligent manner so as to endanger to the life. TVS. You are the owner of motorcycle K41 Bajaj Discovery. Yes, finding is that have you appeared before the tribunal? RW1 Satish. Who is Satish? Satish is that respondent number 1. Yes. Has he given complaint? Is it your case that police has not taken your complaint? That all that is not will be there for your defense. Immediately after the accident, if that deceased himself is the negligent, have you given a complaint to the police saying that he is negligent? Then how can you distinguish, madam? Yes, you deposit 50%. Again, some amount under how much? Yes, you give that. No, you pay another 2 lakhs, madam.
7 lakhs
See, you have not given complaint, no documents has been produced, right? Even assuming that it is in a contributory negligence, at least you are entitled for 50%. 7 lakhs kotidare, 2 lakhs kotidare, in 2 lakhs you deposit. Then you take notice, yes, notice. Now, if you want to stay, that is what that normally will grant the stay 50%. I thought 2 lakhs could try in. Yes, you give another 2 lakhs. It is your liability, madam. What will be that person who has suffered? That is not the issue. Why you have not taken an insurance policy? You can't, use that vehicle on the road without that policy. Is it not? Is it your case? Policy is expired, or you are not taking a policy? And yes, heard. Issue notice. Learned Counsel for the appellant has submitted that. As per that award, the appellant has deposited 2 lakhs before that executing court in execution number. Which is that execution number? Nine one nine of 2021. In which court? Yes, 9-1 before that executing court. The claimant, the appellant is directed to deposit further 1 lakh rupees before the tribunal. Subject to that, stay of judgment and award dated 12th August 2021, passed by MEACT Bangalore in MEAC 2387 of 2018 for a period of 8 weeks. Yes. Yes. Yes, Mr. Yes, Mr. Krishna.
This is 2040 award. Even did not possess and is effective as on the date of occurrence of accident.
Now, what is that finding of the tribunal regarding that?
Second one is he did not possess transport license as on the date. He obtained transport license post 1 year in subsequent. Therefore, as on the date of occurrence of accident, he did not living there. The learned friend was believing that he will be able to pay before compensation.
No, that tribunal has given that it is a light motor vehicle.
Transport vehicle or
That Mukund Devan case is not applicable.
Once law laid down in that case is not correct. It is referred to a larger bench by 3 judges. Case of paid recovery last order motion Mukund Devan 3 judges bench. 5 judges bench all claimants they started asking any event paid recovery or paid recovery. In all the cases they passed out of paid recovery.
Where is
the Devan's case, whatever liability insurance company. Those cases, no liability on insurance. But however, paid recovery is not.
Where is that? No, that the law on that point is just because matter is referred to that larger bench. But all benches has
Before ಮಾಡಿದ ತಕ್ಷಣ ಏನಾಗುತ್ತೆ? So it has to go to larger bench. ಯಾವ್ದು correct?
no, the law is that till that has to be decided unless Mukund Devagan case is stayed.
Stay ಮಾಡೋದಕ್ಕೆ ಸಾಧ್ಯವಿಲ್ಲ ಯಾರು.
No, that is law is that. See, we can't wait till that larger bench has to be decided. Till then, the law laid down by the Supreme Court is enforced. See, very same issue has been. No, not only that. Yeah. Allah, not only this, you forget about the tribunal. In our High Court, this issue has been argued, and referring the Supreme Court said that Supreme Court judgment and passed an order that Krishna Dixit, after following that Supreme Court, Supreme Court judgment is there. Yes. Before we part, we must note that all the learned counsel appearing for the insurance company have fairly submitted that. What law, that is to say that following the principle laid down in the Mukund Devagan has either been paid in full, shall pay terms of therefore in terms of records.
So bring the matter to larger bench. The honorable next court has said that the insurance company undertaking was taken into consideration, and
Direction. They have to pay.
yes, they have to pay.
Supreme Court still you have seen.
Paid in full, should be paid. That is the undertaking. Totally, ಒಂದೇ ಕೇಸ್ ಅಲ್ಲ, ಬೇರೆ ಯಾವುದೇ ಕೇಸ್ paid recovery. Because they want this case in LMB license, LMB transport. Paid recovery.
Yellide, that is not there. Yes.
Before we start,
Yes.
we must note that all the elected bidding from the insurance have clearly submitted. The compensation in terms of the directions issued to the courts below.
Yes.
It is to say, following the principles laid down in the Devagan has either been paid in full or will be paid in terms of such directions. Really now what we mean. Their statements are recorded.
Mukund Devagan ಪ್ರಕಾರ ಎಲ್ಲ ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ಅದನ್ನೆಲ್ಲ ಕೊಡ್ತೀವಿ ಅಂತ ಒಪ್ಪಿಕೊಂಡಿದೆ.
ಇಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ. That's no. The judgment.
See, when it is referred. March 3, 2022 law. Yes, that we have undertaken that we will pay that as per that Mukund Devagan case. No liberty is reserved for recovery. No liberty is, you yourself voluntarily said, yes, in terms of the Mukund Devagan, you will, pay, but you refer. That is what that your concession. ಆಯ್ತು ಸ್ವಾಮಿ ನಾವು ಕೊಟ್ಬಿಡ್ತೀವಿ ಆಯ್ತು ಈ ಕೇಸನ್ನು ಮಾತ್ರ ರೆಫರ್ ಮಾಡಿ ಫಸ್ಟ್ ಲೆಟ್ ಅಸ್ ಸಿ ಇನ್ ಫ್ಯೂಚರ್ ಅನ್ನೋ ಪ್ರಶ್ನೆಯಲ್ಲಿ ಇದೆ. ಇಲ್ಲ 9 ಆದ್ಮೇಲೆ 10 ಪೇಜ್ ಕರೆಕ್ಟ್ ಇದೆ. ಆಯ್ತು ನೋಡಿ ಹೇಳಿ. You want tomorrow also we'll have it. When do you want? Monday.
more than 6 months, ಯಾವುದೋ wait ಮಾಡಬಾರದು ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
Yes, release this matter after 2 weeks. You verify, otherwise. Allah, Mukund Devagan case. No, we can't do like that, Mr. In one case, different. Either I may pass an order all this day, but today, if he convinced and show that some other judgment, I can change my judgment. It is not that whatever I have ordered earlier, it has to be carried. Ee case alli sumne concession anta madak agala. Now, as on today, I have taken a stand that pay and recovery. Till Supreme Court judgment has to shown and convinced. Allah, that will be different. That will see that. Allah, he has produced the documents. He was carrying that vegetable to that APMC yard that he has shown last time, 2 days back. When you are not there, therefore I have urgent. Yes. Now you will see next week. If you want to see this order, you can see them. If you yourself is not sure that whether it is entire order is there or not. Yes, next week. No, Mr. Kumar, if that is the case, then from today onwards or after you are showing that judgment, I have to change my stand. Unless, as on today, there is no such. That is what that. If Supreme Court said, I have to say my order itself is not correct because it is a Supreme Court. That we can change, there is no problem. But thing is that as on, then I have to say that next week. Refer. No, yes.
Correct. Against law of the Madhud, don't be referred to larger range and part of it. It should prevail. And hereditary, points. Not declared in
Allah, see, Mukund Devagan itself is order on the basis of the reference. Alva adun mat refer madidara. Inmel adak mat reference madalla anta kaansutte. Now we are seeing so many cases reference to reference.
Most unfortunately, provisions of act.
Allah, reference yake review madak baralla.
Refer ಮಾಡದಲ್ಲ 2 judges 3 judges 3 and 4.
Allah, 3 judges bench do, if that law has not been properly considered, it is a case for review. You could have filed a review instead of idenu gotta 3 judges reference na matte reference. It's idurna section 24 of Land Acquisition Act hinge aitu. Yes, let us see. Yes, so if that latest order is that, then have to consider. Otherwise, I will follow that. Yes. No, he wants next week. Dispense madak barala. Let us see. Let us see what is that this thing. If that I confirming that judgment and all, then his presence is not necessary. Yes. The request of counsel for the appellant. Release this matter 2 weeks. Yes.
Krishnaswamy for appellant. Pradeep CS.
My lord, I am appearing for the respondent, my lord. My lord, in this case, I request for 2 weeks time, my lord, because I have to file a list of authorities, my lord.
Not liable. latest Supreme Court judgment includes covered the decision. Still they
Yes, Mr.
My lord, it's regarding with the act and package policy, my lord. Our policy is a package policy. So
There is
the trial court
where
has
is that? Where is that policy? You show that policy. That is the end of the matter.
my lord, it's a
owner is insured. Takes a policy. He's having a
Yes, yes.
Liability incurred by him, whatever liability incurred, insurance policy will cover it. Then any file a claim
PA coverage ಬರಲ್ವಾ?
PA coverage ಖಂಡಿತ ಬರುತ್ತೆ, provided he is a rider cum owner cum driver. Rider ಮಾಡ್ತಾರೆ. PDN rider ಆಗುತ್ತೆ.
No, the policy says owner come driver or owner and driver.
Owner cum driver. Dash ಆಗ್ತಾರಲ್ಲ English ಅಲ್ಲಿ. Cum ಅಂತ ಅರ್ಥ ಮಾಡ್ತಾರೆ.
No, because in one more policy it has been said owner and driver. That avaga then
owner dash driver.
It's come. Yes. No, because in one policy it was there. I read some judgment. They said owner and driver ಅಂತಂದ್ರೆ ಓನರಿಗೂ ಆಗುತ್ತೆ ಆಸ್ ಎ ಡ್ರೈವರ್ ಆಗುತ್ತೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಿ ಎಸ್
ಅದಕ್ಕೋಸ್ಕರನೇ ಈ ಪಾಲಿಸಿ
ನೋಡಿ yes there is a stay. You are enjoying that entry matter, is it not? Compulsory PA owner
dash driver.
Owner dash driver ಅಂದ್ರೆ ಓನರ್ ಕಮ್ ಡ್ರೈವರ್. Yes.
Our owner dash section 3 ಇದೆ policy.
Section 3, yes. Condition 3 na. Alla ellide? Where you are reading? Oh, section liability. Terms of subject.
Otherwise, terms, exceptions, conditions, and limitations of this policy, the company undertakes to pay compensation as per the following scale for bodily injury that is sustained by the owner cum driver of the vehicle in direct connection with the vehicle. Insured or while dismounting from a traveling insured vehicle as a co-driver caused by violent in the visible means, it's independent of any other cause, shall within 6 calendar months.
Now, what is that co-driver? No, for two-wheeler, you are not considering co-driver. Now, where? Yes.
Compensation shall be payable. Only one of the items wants to be no compensation shall be payable in respect of death or birth injury directly or indirectly, only or amazing from reasonable sources. Subject this cover is subject to the owner driver is the registered owner of the vehicle insured herein number 1. This cover is subject to
Which page you are reading?
same.
See, section 2 ಇದೆ, section 1 ಇದೆ, ಇದ್ರಲ್ಲೇನು ಉಲ್ಟಾ ಹಾಕ್ಬಿಟ್ಟಿದಾರ ಅಂತ. 1 section 3 personal accident cover for the owner driver.
This cover is subject to the owner of the driver is the registered owner of the vehicle
Insured here.
ನಾವೆಲ್ಲ ಇದುವರೆಗೂ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ಅವರು ಒಬ್ಬ ವ್ಯವಸ್ಥೆ ನಮಗೆ owner driver is the insured named in this policy. Insured owner ಆಗೋದಿಲ್ಲ, policy ನಿಂದ ಒಬ್ಬನೇ owner ಅಂತ ಆಗಿರ್ಬೇಕು. Okay, condition. Owner driver holds the effective driving license in accordance with the provisions of the Central Rule 1882. Time of accident. Who is co-driver ಆಗಿದ್ದು ಸಹ ಅವರೇ
ಅದೇ ಅದನ್ನ ಎಲ್ಲ ನೋಡಿದೆ. ಕೋ ಡ್ರೈವರ್ ಇಫ್ he is having a driving license and traveling, then he can be owner ಆಗಿದ್ದು. Yes. ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
The reasons.
Anyhow, he is not ready. You have to spend. When do you want, Mr.?
Malad, next week, Malad. The second, Malad.
Yes, at the request of counsel for respondent, release this matter next week. Yes.
Much.
Case number 60 adjourned. Case number 61. And business Swami for appellant.
Yes, what is this, Mr.? Connected matter claim challenge ಮಾಡಿದ್ದೀರಾ? If other case is held, then same thing as if negligence is on your part. Follows. Now you have taken the contention that insured as not having a valid driving license, but we'll see that corrected matter. Yes, 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 yes. Yes. Sorry. ಅಲ್ಲ in terms of that we can ಯಾಕಂದ್ರೆ ಒಂದರಲ್ಲಿ ಹೇಳಿದ್ಮೇಲೆ yes ಶ್ರೀ N. Krishnaswamy Learned Township appearing for the insurance company has contended that the accident has contended that the driver of the offending vehicle was not having valid and effective driving license. The insurance company is not insured as violated the policy condition. The insurance company is not liable to pay that compensation. In respect of very same extent, 2 claim petition has been filed. In respect of MEC 2433 of 2010, the MFA 10364 of 2011 has been filed by the insurance company has challenged by filing a separate appeal in MFA 10364 of 2011. This court by order dated 13th February 2019 has dismissed the appeal, confirmed the judgment and award passed by the tribunal. In view of the judgment and award dated 13th April 2019 passed by this court in MFA 10364 of 2011, this appeal is also dismissed, confirming the judgment and award passed by the tribunal. Amount in deposit is transferred to the tribunal.
Number 52, Prakash for appellant, N. Krishnaswamy.
Yes, Prakash. None appear for the appellant. Release this matter of 2 weeks.
Number 63, adjourned. Cell number 64, SBI Vidamulkon for appellant, NR Ravi Kumar.
Segade, pass out.
Number 65, O Mahesh for appellant, connected matter, Suresh and Lathor.
Yes, pass out.
66, adjourned. Cell number 67, N. Krishnaswamy for appellant, connected matter.
Yes, Mr. Krishnaswamy, what is this? He was a passenger being carried in the goods carriage.
Employees of one compartment. How many years? 18 employees.
That is it is proved.
It's like E1.
Yes.
vehicle.
Yes.
Pickup branch.
It's ಕೊಟ್ಟಿದ್ದಾರೆ 50,000, 43,000, 65%. Yes.
ನಾನು ಈ ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ವಾಸವಾಗಿರುತ್ತೇನೆ. ನಾನು ಈ ದಿವಸ ನಮ್ಮ ಗ್ರಾಮದ ವಾಸಿಗಳಾದ ಪಾಪಮ್ಮ, ಪಾಪಚ್ಚಿ,
ಗೀತಾ,
ಪಾಪಚ್ಚಿ, ಪಾಪಚ್ಚಿ, ಗೀತಾ, ಕವಿತಾ, ವಿಜಯ, ಚಂದ್ರಮ್ಮ, ಜಯಮ್ಮ, ತುದಿಯಮ್ಮ, ಸರೋಜಮ್ಮ, ಲಕ್ಷ್ಮಮ್ಮ, ಮಂಗಿ, ಭಾಗ್ಯ, ಪುಷ್ಪ ಹಾಗೂ ಕಲ್ಲತ್ತಿಪುರದ ವಾಸಿ ಚಲವರಾಜ್, ಪುಷ್ಪ, ಮರಿಯಮ್ಮ, ಮೇರಿ, ಇಂದ್ರಾಣಿ ಇವರೊಂದಿಗೆ ಕೂಲಿ ಕೆಲಸಕ್ಕೆ ರಾಮಗಿರಿ ಕಾಫಿ ತೋಟಕ್ಕೆ ಹೋಗಿ ಕೂಲಿ ಕೆಲಸ ಮುಗಿಸಿಕೊಂಡು ವಾಪಸ್ ನಮ್ಮಗಳ ಊರುಗಳಿಗೆ ಬರಲು KA 168942 ನಂಬರಿನ ಟೆಂಪೋ ಟ್ರ್ಯಾಕ್ಸ್ ಗೂಡ್ಸ್ ವಾಹನದ ಹಿಂಬದಿಯ ಬಾಡಿಯಲ್ಲಿ ನಾವುಗಳೆಲ್ಲರೂ ಉಳಿದುಕೊಂಡು ಮಧ್ಯಾಹ್ನ ಸುಮಾರು 2 ಗಂಟೆಯಲ್ಲಿ ಸಂತಮೇರಿ ಘಾಟಿಯ 1ನೇ ಕರುವಿನಲ್ಲಿ ಬರುತ್ತಿರುವಾಗ KA ಚಾಲಕ ತೀರ್ಥಪ್ಪ ಎಂಬುವರು ಸದರಿ ವಾಹನವನ್ನು ಕಾಯಿಸಿಕೊಂಡು ರಸ್ತೆಯ ಮೇಲೆ ಎಡಬಗ್ಗುಲಾಗಿ ಎಡವಿದ ಪರಿಣಾಮ
Now, what is the capacity? See, what is the seating capacity?
Cabin capacity is the capacity. Very clear.
No, that is true. What is that section 100 of our motor vehicles rules, state motor vehicles rules?
Employer and employee relationship is that. Vehicle goods carriage cannot be used for carrying passengers.
That is true. That is, see, first of all, even assuming that there has an employer, employee, whether he can carry this much of persons. What is that section 100 of our motor vehicle rules says?
Indicate that so many persons could be carried in a goods carriage.
Idu which is the
carry ಮಾಡಬಹುದು. Carry ಮಾಡಬಹುದು goods carriage. Insurance company or liability 147 policy. ಈ ರೀತಿ ತಗೊಂಡು ಹೋಗಿದ್ದು 6 ಜನ.
Other, but your liability is only to that extent what is covered under the part. Yesterday other capacity as to insured. Yes, that is. Now that see that policy.
Exhibit R1.
Yes. Yes.
Seats 0.
Where you are ready?
Policy ನಲ್ಲಿ seats GVB gross vehicle weight. Gross vehicle weight is 1785. Hinbagನಲ್ಲಿ 0 ಆಗಿದೆ. The seats policy
ಮೊದಲನೇ ಪೇಜ್ LPG unit total.
IDV vehicle non electrical accessories ಅಂತ ಇದೆಯಲ್ಲ ಅದರಲ್ಲಿ CNG ಯೂನಿಟ್ ಇಲ್ಲ, LPG ಇದು ಅದಕ್ಕಿಂತ ಮೇಲ್ಗಡೆ ಬರುತ್ತೆ. ರಿಜಿಸ್ಟರ್ಡ್ ನಂಬರ್ ಇದೆ.
Yes, yes. Registered number, engine number.
KA 168942.
Yes.
So T Bajaj pickup light goods vehicle 2003.
Yes.
Seats 0. Gross vehicle weight 1785.
Yes.
Premium is 8,609. This one day, nobody else can be carried.
Yes.
The cabin capacity. Number 1. Number 2, nobody could be carried on body.
No, you have covered the 2 employees. WC2 employee 2.
WCT employee 2.
That is
Employees, 2 employees, employees of the insured.
insured.
May not make any sense. Ziaullah.
Whether they are employees or not. If they have proved that they are employees, 2 persons are entitled.
Are entitled to get compensation provided these people were working at a Ziaullah.
Yes, that is yes. Yes.
Carrying capacity. Insurance carriage.
They are the employer of that insured. Yes, that is the main.
Basis. He complained that Ziaullah employees.
What they said? ನಾವು ಈ ದಿವಸ ನಮ್ಮ ಗ್ರಾಮದ ವಾಸಿಗಳಾದ ಸೋನ್ಸು ಎಂಬುವರು ಕೂಲಿ ಕೆಲಸಕ್ಕೆ ರಾಮಗಿರಿ ಕಾಫಿ ತೋಟಕ್ಕೆ ಹೋಗಿ ಕೂಲಿ ಕೆಲಸ ಮುಗಿಸಿ ಬಂದು ವಾಪಸ್ ನಮ್ಮಗಳ ಊರಿಗೆ ಸೋನ್ಸು ಟೆಂಪೋ ಟ್ಯಾಕ್ಸ್ ವಾಹನದ ಹಿಂದಿ ಬದಿಯಲ್ಲಿ ಅವುಗಳಲ್ಲಿ ಕುಳಿತುಕೊಂಡು ಮಧ್ಯಾಹ್ನ he has taken this agent for rent. ಅವನ್ ವೆಹಿಕಲ್ ಅಲ್ಲಿ ರೆಂಟಿಗೆ ತಗೊಂಡು ಬೇರೆ ಯಾರೋ ತೋಟಕ್ಕೆ ಜನ ಹೊಡಿತಾ ಇದ್ದ. What is that evidence?
Evidence must be law of the
Yes.
Evidence because
No, this is complaint. What is that evidence given before the tribunal? Complaint kotirada is also complaint the claimant. Yes.
WCA NF 24.
Yes. The first case is respect of climate. Yes. ಮೇಲಿನ 3 ಜನ ಅರ್ಜಿದಾರರು ಸೋನ್ಸೋ ಕಾರ್ಮಿಕ ಕಾಯ್ದೆ ಅಡಿಯಲ್ಲಿ ಸೋನ್ಸೋ ತಮ್ಮ ಅರ್ಜಿಯಲ್ಲಿ ಸಂಗತಿ ಸಬಕಪಡಿಸಿದ ಈ ನ್ಯಾಯಾಲಯದ ಹಾಜರಾಗಿ ನೋಡಿದ ತಮ್ಮ ಸಾಕ್ಷಿ ಸೋನ್ಸೋ ಇವಾಗ ಸಮನ್ ಸ್ವೀಕರಿಸಿದ್ದು ನಾವುಗಳ ಸಂದೇಶ
is the document that they have to use. Complaint and ignore or violate this. Statements ನಾನು ಲೋಡರ್ ಅನ್ಲೋಡರ್ ಕೆಲಸ ಮಾಡುವವನಾಗಿದ್ದು ದಿನಾಂಕ 14/3/2008 ಮಧ್ಯಾಹ್ನ 2 ಗಂಟೆ ವೇಳೆಯಲ್ಲಿ 1ನೇ ಪ್ರತಿವಾದಿಯವರ ಆದೇಶದ ಮೇರೆಗೆ ಈಗ ನಾನು ಅವರಿಗೆ ಸೇರಿದ ವಾಹನ ನೋಂದಣಿ ಸಂಖ್ಯೆ KA 168942 ಲೋಡರ್ ಅನ್ಲೋಡರ್ ಆಗಿ ಪ್ರಯಾಣಿಸುತ್ತಿದ್ದೆ ಆದೇಶ ಆ ಸಮಯದಲ್ಲಿ ಸದರಿ ವಾಹನ ಚಾಲಕನ ಅತಿಯಾದ ಬೇಗ ಹಾಗೂ ಅಜಾಗರೂಕತೆಯಿಂದಾಗಿ ಸದರಿ ವಾಹನ ರಸ್ತೆಯಲ್ಲಿ ಕುಳಿತು ಆಗಿತ್ತು ವಾಹನಗಳು ಸೇರಿಸ್ತಾರೆ ಅವರು ಹೇಳಿದ್ರು ಆದೇಶದ ಪ್ರಕಾರ ಮಾಡಿದ್ರು.
ಅಲ್ಲ, but that is not the case that the vehicle has been taken for any work. Yeah, even then they are on that instructions, they are traveling, but not for his work.
Not for the work of the insurer.
Yes.
When I cross-examination, the contents of the
Contents of PW?
is PW1.
Yes.
ಅಪಘಾತದ ನಂತರ ನಾನು ಪೊಲೀಸರಿಗೆ ಹೇಳಿಕೆ ನೀಡುತ್ತೇನೆ ಎನ್ನುವುದು ಸರಿ. ಪೊಲೀಸರಿಗೆ ಅರ್ಜಿಯಲ್ಲಿ ಹೇಳಿರುವ ಅಪಘಾತ ಹೇಗೆ ಸಂಭವಿಸಿರುತ್ತದೆ ಎಂದು ತಿಳಿಸಿರುತ್ತೇನೆ ಎನ್ನುವುದು ಸರಿ. ಅವರೇ ಪೂರ್ತಿ ಒಪ್ಪಿಕೊಂಡು ಅಪಘಾತದ ದಿನದಂದು ವಾಹನದಲ್ಲಿ ಸುಮಾರು 15ರಿಂದ 20 ಜನರಿದ್ದರು ಎನ್ನುವುದು ಸರಿ. ನನಗೆ ರಾಮಗಿರಿ ಎಸ್ಟೇಟ್ ಗೊತ್ತಿದೆ. ಅಪಘಾತದ ದಿನದಂದು ಸದರಿ ವಾಹನದಲ್ಲಿದ್ದ ವ್ಯಕ್ತಿಗಳು ನನಗೆ ಪರಿಚಯಸ್ಥರು ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಇದು ಸಾಮಾನ್ಯ ಮಾಸ್ಟರ್ ಅಂಡ್ ಸರ್ವೆಂಟ್ ರಿಲೇಶನ್ಶಿಪ್ ಮಾಡಬಹುದು. ಹೈರ್ ಅಂಡ್ ಫೈರ್, ಪೇಯಿಂಗ್ ವೇಜಸ್, ಇವರೇ ಕಾನ್ಸೆಪ್ಟ್ ಕೂತ್ಕೊಳ್ಬೇಕು.
ಸರಿಯಲ್ಲ. They have made a suggestion, but he has denied that.
ಈ ಪ್ರಕರಣದ 1ನೇ ಪ್ರತಿವಾದಿಗಳು ನನಗೆ ಯಾವುದೇ ವೇತನವನ್ನು ನೀಡುತ್ತಿರಲಿಲ್ಲ, ರಾಮಗಿರಿ ಎಸ್ಟೇಟ್ ನಮಗೆ ವೇತನವನ್ನು ನೀಡುತ್ತಿದ್ದು ಸೂಚಿಸುವುದು ಸರಿಯಲ್ಲ. ಅಂದ್ರೆ ಇವ್ರು ಕೊಡ್ತಿರ್ಲಿಲ್ಲ, ರಾಮಗಿರಿ ಎಸ್ಟೇಟ್ ಕೊಡ್ತಾರೆ
ಅಂತ ನಿಮ್ ಸಜೆಷನ್ ಅನ್ನ
ಡಿಲೇ ಮಾಡಿ ಯಾರು ಕೊಡ್ತಾರೆ. ಈ 3ನೇ ಲೈನ್ ವಾಹನದ ಇತರ ವ್ಯಕ್ತಿಗಳು ಏನು ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದರು ಎನ್ನುವುದರ ಬಗ್ಗೆ ನನಗೆ ತಿಳಿದಿರುವುದಿಲ್ಲ. ನಾನು ಅಪಘಾತಕ್ಕೊಳಗಾದ ವಾಹನದಲ್ಲಿ ಲೋಡರ್ ಮತ್ತು ಅನ್ಲೋಡರ್ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದರು. ಸಿಲ್ವರ್ ಗಿಡಗಳನ್ನು 17 ಜನ ಟ್ರಾವೆಲ್ ಮಾಡೋದ್ಮೇಲೆ ಸ್ಪೇಸ್ ನನ್ನನ್ನು ಈ ಕೆಲಸಕ್ಕೆ ತೀರ್ಥಪ್ಪ ಎನ್ನುವರು ಕರೆದುಕೊಂಡು ಹೋಗಿದ್ದು, ನನ್ನ ವೇತನವನ್ನು ಕೂಡ ಅವರೇ ನೀಡುತ್ತಿದ್ದರು. ವೇತನ ಯಾರು ಕೊಡ್ತಾ ಇದ್ದಾರೆ?
where you are reading?
Page 4 cross-examination.
ಆಯ್ತಾ, which is last line? ವೇತನವನ್ನು ಕೂಡ ಅವರೇ ನೀಡುತ್ತಿದ್ದರು. ಅಪಘಾತ ವಾಹನ ಎಸ್ ನನ್ನನ್ನು ಈ ಕೆಲಸಕ್ಕೆ ತೀರ್ಥಪ್ಪ
ಎನ್ನುವರು ಕರೆದುಕೊಂಡು ಹೋಗಿದ್ದು,
ನನ್ನ ವೇತನವನ್ನು ಕೂಡ ಅವರೇ
ನೀಡುತ್ತಿದ್ದರು.
ಎಸ್
ಯಾರೋ ಕರ್ಕೊಂಡು ಹೋಗ್ತಾರೆ, ಯಾರೋ ಮಾಡ್ತಾರೆ, ಇನ್ಯಾರೋ ಗಾಡಿ WC ಕೇಸ್ ಬರೋದು. ರಿಸ್ಕ್ ಇಸ್ ನಾಟ್ ಅಸ್ಯೂಮ್ಡ್ ಅಂಡ್ ಪಾಲಿಸಿ. ಅದಕ್ಕೆ ಈ ರೀತಿ ಬೈಕ್
yes. No other witness has been examined.
ಎಲ್ಲರೂ ಕ್ಲೈಂಟ್ಸ್ ಎಲ್ಲರೂ ಇದೆ.
Now, what has happened to that? This your amount has been withdrawn. Alla madlebekalla. It's WC. What has happened that is it withdrawn?
According to my instructions,
Deposited here or yes.
That is delayed. You will have to
ಏನು withdrawn ಆಗಿಲ್ಲ. Yes. Other side is not served under. Allah, other side served unrepresented. I will disclose. Yes, 1:30 I will dictate. Yes, yes. Yes, yes. Also.
Matter O minus.
Yes, Mr. Huh? 60. Once. Pass over ಆಗಿದೆ. Yes, at the request of council for respondent number 2, release this matter next week. And if you are there, we can dispose of afternoon. Now, let us see 1:30. Yes.
Put up, sir.
ಹೇಳಿ ಸರ್.
Put up, sir.
ಹಾ ಹೇಳಿ ಹೇಳಿ ಸರ್, ಕೇಳಿಸ್ತಾ ಇಲ್ವಾ?
Put
ಸರ್
up,
ಮಹೇಶ್
sir.
ಕೇಳಿಸ್ತಾ ಇಲ್ವಾ ಸರ್ ಮಹೇಶ್ ಅವರೇ?
ಹಾ, ಕೇಳಿಸ್ತಾ ಇದೆ ಇವಾಗ.
ಹೇಳಿ ಸರ್, ಹೇಳಿ ಸರ್.
ಸರ್, ಸೀರಿಯಲ್ ನಂಬರ್ 41 ನಲ್ಲಿ TCR ಅಂತ ಇತ್ತು.
41 ಅದು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಗಿದೆ ಸರ್.
48 ಸರ್.
48 ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ಸರ್.
65 ಮಧ್ಯಾಹ್ನ ಬರ್ತಾರಲ್ವಾ?
ಮಧ್ಯಾಹ್ನ ಬರ್ತಾರೆ. 65 ಪಾಸ್ ಓವರ್, 68 ಪಾಸ್ ಓವರ್.
ಓ, ಎಲ್ಲ
ಎಲ್ಲ ಪಾಸ್ ಓವರ್. ನೀವು ಮಧ್ಯಾಹ್ನ ಬರ್ತೀರಾ ಅಂತ ಮಧ್ಯಾಹ್ನ.
ಇಲ್ಲ, ಏನ್ ಸರ್ 4 ಕೋಟಲ್ಲಿ ಹಾಕ್ಬಿಡ್ತಾರೆ, ಪಜೀತಿ ಆಗೋದು.
ಹೌದಾ?
ಅದು 24ನೇ ಕೋಟಲ್ಲಿ ತಗೊಂಡ್ಬಿಟ್ರೆ ಬಿಡದೇ ಇಲ್ಲ ಅವರು.
ಸರ್ 44 ಪಾಸ್ ಓವರ್ ಆಗಿದೆಯಾ ಸರ್?
ಹಾ ಸರ್, ನೋಡ್ತೀನಿ. 44 ಪಾಸ್ ಓವರ್ ಸರ್.
ಥ್ಯಾಂಕ್ ಯು.
ಓಕೆ ಸರ್.
High Court of Karnataka.
Court officer? Court officer? Judge ಎದ್ದೇ ಹೋಗ್ಬಿಟ್ಟು. Court officer? Court officer?
ಅವ್ರು ಊಟ ಮಾಡ್ತಿರ್ತಾರಮ್ಮ.
ಅಲ್ಲ ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್
ಹೇಳಿ ಮೇಡಮ್ ತೊಂದ್ರೆ ಇಲ್ಲ ಹೇಳಿ ಮೇಡಮ್ ಆಯ್ತು.
ಸಾರಿ ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 45 ಏನಾಯ್ತು ಸರ್ ಅದು ಅರ್ಜೆಂಟ್ ಆಯ್ತಾ 45 ಸಾರಿ ಸರ್ ನಾನು ಇನ್ನೂ ಸಾಹೇಬ್ರು ಇದಾರೆ ಅನ್ಕೊಂಡು ಆಗಿದ್ದ
ಪಾಸ್ ಓವರ್ ಆಗಿದೆ.
ಪಾಸ್ ಓವರ್ ಆಗಿದೆಯಾ 45?
ಹೌದಮ್ಮ.
ಓ ಸರಿ ಸರ್
ಊಟ
ಊಟ ಮಾಡಿ.
ಆಯ್ತು ಸರ್ ಥ್ಯಾಂಕ್ ಯು.
ಊಟ ಆಯ್ತಾ?
ಲಾಗೌಟ್ ಆಗ್ಬಿಟ್ರು ಬಿಡಿ ಸರ್ ನಾಗರಾಜ್ ಸರ್, ನೀವು ಊಟ ಮಾಡಿ.
ಆಯ್ತು ಸರ್.
ಓಕೆ ಸರ್. ಸರ್ 12 ಇಂದ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಸರ್?
ಕೇಳಿಸ್ತಾ ಇದೆ.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು. ಇದು ನೋಟ್ಸ್ ಪೇಜ್ ಚೇಂಜ್ ಮಾಡ್ದಪ್ಪ. ನೋಟ್ಸ್ ಪೇಜ್ ಚೇಂಜ್ ಮಾಡ್ದ. ಖಾಲಿ ಐತಾ ಪೇಜು? ಹೌದಾ
ಸರ್ ಪಾಸ್ ಓವರ್ ಎಷ್ಟಿದಾವ ಸರ್? 44.
ಎಲ್ಲ ಪಾಸ್ ಓವರೇ ಸರ್. ಈಗ ಒಂದು ಡಿಟೇಷನ್ ಇದೆ ಕೃಷ್ಣಸ್ವಾಮಿ ಸರ್ದು, ಆಮೇಲೆ ಪಾಸ್ ಓವರ್.
ಸರ್ ಒಂದು ಮೊದ್ಲೇ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ತಗೋಬೋದಾ ಸರ್ ಟೈಮು?
ಬೇಡಿ ಮೇಡಮ್.
ಹೌದಾ ಸರಿ, ಅದ್ ಬಂದಾಗ ಹೇಳದ ಸರ್?
ಬೇಡ ಬೇಡಮ್ಮ, ಬಂದ್ಬಿಡುತ್ತೆ ಒಂದ್ 5 ನಿಮಿಷ ಅಷ್ಟೇ.
ಆಯ್ತು ಸರ್, ಆಯ್ತು ಸರ್.
ಓಕೆ, ಅದು ಹಂಗೆ ಹೇಳಕ್ ತಿರ್ಗಾ ಗಲಾಟೆ ಯಾಕೆ?
ಆಯ್ತು
ಸರಿ ಅಮ್ಮ,
ಆಯ್ತು ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಓಕೆ ಸರ್. ಏನೋ ಕೇಳಿದ್ರಿ ನಾಗರಾಜ್ ಸರ್?
ಅಲ್ಲ 44 ಸೀರಿಯಲ್ ನಂಬರ್ ಅಷ್ಟೊಳಗಡೆ ಎಷ್ಟು ಪಾಸ್ ಓವರ್ ಆಗಿದಾವೆ ಅಂತ ಒಂದಷ್ಟು.
ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಎಷ್ಟಾಗಿದೆ ಅಂತನಾ?
ಹಾ
ಹೇಳ್ತೀನಿ ಸರ್.
ಅಂದ್ರೆ ರೀಚ್ ಆಗುತ್ತೋ ಇಲ್ಲ ಅಂತ ಒಂದಷ್ಟು.
ಇಲ್ಲ ರೀಚ್ ಆಗುತ್ತೆ ಎಲ್ಲ. ಒಂದ್ ನಿಮಿಷ ಹೇಳ್ತೀನಿ. 1 2 3 ಸರ್ 4 ಇದೆ. 44ಕ್ಕಿಂತ ಮುಂಚೆ 4 ಇದೆ.
ಸರಿ ಸರ್,
ಓಕೆ ಸರ್,
ಥ್ಯಾಂಕ್ ಯು.
ಓಕೆ ಸರ್.
ಫೋನ್ ಮಾಡಿ ಬೆಳಿಗ್ಗೆ
ಅದು ಹಳೆದೇ
ನಾನೇ ಬಿಟ್ಟು ನೋಡಿ, ಒಂದರಿಂದ ಸೀದಾ ಮಧ್ಯೆ ಗ್ಯಾಪ್
Number 67. Memo accepted paper publication service. Sharing post ಆಗಿದೆ. Again, essential question. Not. They are ignored. Question frame ಮಾಡಿಲ್ಲ ಸರ್. Essential question of law arises for consideration. Question of law 1. Shri N. Krishna Swami, the council appearing for climate has insurance company has contended that the climate was traveling the offending vehicle as a paid passenger stroke unauthorized passenger. Totally. 14 members was traveling in that goods vehicle. Same is evident from the complaint produced as Exhibit E1. The claimant, Aulappa himself is the complainant. He further contended that the claimants are admitted in their evidence they have admitted that Tirthappa was paying salary to the claimants. It is very clear that they are not working employee under the respondent. He further contended that the claimant has not produced any document to the relationship of employer and employees. On the other hand, in the complaint and the evidence, they have admitted that they were traveling in the offending vehicle for working at Ramagiri Estate. The tribunal has failed to consider this aspect of the matter. Error in held that claimant was working under the respondent and they have suffered an injury during the course of the employment. Respondents are served unrepresented. The matter was admitted on 6/3/2017. Today, the substantial question of law framed for consideration is as follows. The case of the claimants that On 14/3/2008, at about 8 p.m., they were proceeded in Bajaj pickup van bearing registration number KA 168942 as a loader and unloader as per the instruction of respondent number 1. While the proceeding near Shantaveri Kharu, the driver of the vehicle has driven the said vehicle with excessive speed in rash and negligent manner, due to which said vehicle was capsized and caused that accident. They suffered an injury. Immediately after the accident, Kalappa, who is a claimant in ECA 75 of 2014, has lodged a complaint in Lingadahalli police station. In the complaint, he has categorically stated that he, along with one Papamma, Papachi, Gita, Kavita, Vijaya, Chandramma, Jayamma, Patiyamma, Sarojamma, Lakshmamma, Pushpa were traveling in the offending vehicle to do the work in Ramagiri estate. Even in the evidence of PW1, that is Kalappa, in his cross-examination, he has categorically admitted that their salary has been paid by one Tirthappa. They have not produced any documents. Therefore, it is very clear that they are not working under the respondent, who is the insured of the offending vehicle. The claimant has not produced relevant documents to establish that, to prove relationship of master and employees between the claimants and the respondent. The tribunal, while allowing that appeal, has failed to consider the FIR, the complaint lodged by Kalappa, and also failed to consider that evidence of the parties. The error in held that the claimant has proved the relationship of master and servant between the claimant and the respondent number 1 and 2. Claimant and respondent number 1. And also error in held that they have suffered an injury during the course of the employment. Accordingly, the the substantial question of law has been answered accordingly. The appeals are allowed. The liability appeals are allowed in part. The liability first and on the insurance company is set aside. The first respondent who is claimed to be a first respondent, since there is no relationship has been proved, therefore the insurance company is not liable to pay that compensation. It's the issue, the substantial question of law has been answered accordingly. The appeal is allowed in part. Accordingly, the appeal is allowed in part. Judgment and award possible tribunal is modified as follows. The first respondent is directed to pay entire compensation amount interest as per the award passed by the commissioner. Amount in the office is directed to amount release agilla, not release. Yes. The registry is directed to refund that amount deposited by the claimant, deposited by the appellant. Refund that amount in favor of the appellant after due verification, if any, deposited by the claimant before this court. All pending applications are disposed of.
Fast forward matter number 2. Number 2, serial number 15.
Yes, 15. Notice to R1 and R2 is discussed. This is matter of 4 weeks.
Serial number 16. Amount can be set is for appellant.
Yes. 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 Yes.
Date of accident is on 13/22/2020.
Yes.
Was aged about 27 years, working as a handheld contractor.
Yes.
However, he was trying to learn for 1 lakh.
Yes.
There is no project to be.
Yes.
According to 12,000 consider instead of 14,000 as per the chapter.
Yes.
And he was inpatient for 6 days in the KMC hospital.
14,500. Yes.
Understand that.
Yes.
And as per the certificate, that is activity 7. There are very previous injury your lordship may kindly go to the discussion.
Yes.
And account of the judgment, your lordship may kindly go to your running page number 14, 1
Yes.
Issue number 3.
That paragraph.
And running page number 14.
Para 10. Yes. Yes.
The petitioner has given evidence to the effect of the sustaining pain and injuries. Petitioner has produced the medical document as so and so. On going through the medical documents, it reveals that petitioner has taken treatment as an inpatient for 6 days to the hospital Nepal. The one certificate has an activity 7. It shows that petitioner has sustained altogether 9 injuries of which 4 injuries should be the remarks are previous in nature. But PW2 Dr. Kiran Achar, who has given treatment to PW1 in this evidence, so also in the disability certificate has it. But Exhibit C1 has explained that petitioner has sustained 2 previous injuries. Injury of open fracture of right distal radius and segmental fracture of right tibia and fibula. It means petitioner has sustained 7 simple injuries and 2 previous injuries. No, my lord, I will read my lord, the CW Dr. Evidence. CW has stated that he has proposed that petitioner has taken treatment as inpatient in the hospital for 6 days. He has completely disability of 80 on right upper limb, locomotor function, and 14 in his right lower locomotor function, and 40% disability with respect to the functional impairment with respect to the occupation has a to further report that petitioner has been advised to undergo implant or remove at later date from the right radius and the right tibia, which requires hospitalization and surgery of the approximately 40,000. And considering the nature of the sustained period of treatment and this to the opinion that petition is obtained to this so and so. Now your lordship can kindly come to paragraph number 21. The head of the disability law 21. Next page.
Yes.
21. So taking into the consideration of the monthly income of the petition having considered by this signal is 12,000 per month. If 10% of loss of working capacity is considered and when the age of the petitioner at the time it was 27 years. So we were the trial court has taken just 10% of disability. The project document with respect to the proof of the advertisement as well as respect to the how injury is affected to the finding. This is not very a paragraph number. I will read the paragraph number. Paragraph number. Support. In view of the above mentioned, he has permanently disability of 18%, 18% field of right upper limb locomotor function and 40% of right lower limb locomotor function. As per Gazette notification by the Government of India, Ministry of Social Justice and Empowerment, Department of Empowerment of Person with Disabilities, 5th January 2018. Locomotor disability assessed as per the guidelines of assessing the extent of specified disability in a person included under the rates of percentage with the Disability Act. So and so, functional impairment with respect to the occupation as a cook 40%. As to the nature of avocation is concerned, 30% as doctor specifically has stated that. However, the London trial court has taken 10%. Then for removal of implants, we got 50,000 doctors we got the evidence. There is no rebuttal evidence by the insurance company with respect to the there is no such disability or there is no effect from the injuries to the nature of avocation. No independent witness has been examined by the insurance company with respect to discard the evidence of the PW2. Because insurance company is always they have a normal sufficient report in all cases is the doctor has taken higher side. But doctor is my witness. I have brought in the report. Because he is a treated doctor or hospital authority sent him. It is my witness. As for the evidence act, if they want to discard that evidence, there must be some rebuttal of the evidence. In the absence of the rebuttal evidence, question of denying my evidence is not justified. That is the whole scope of the and ambit of the Indian Evidence Act 1872. My other submission report is one that my lord, he is my doctor. I brought him. I have my lord requested him. Yes. According to my lord, he has to line the evidence. And if he is failing to pass application and if he is unable to discard my lord my evidence, then my lord, I am not responsible for the my lord any other issues. I am only responsible to prove my case. Accordingly, I have proved as per the issues which has been framed under Order 14(1)(a) and B. Issues on fact and issues on law. About my lord, may I submission. The lordship may kindly consider the 40% of disability. This doctor has not let the evidence. And my lord, medical expenses my lord rightly considered by the London trial court. And marriage hospital also not considered my lord. The assessment of disability, look about the disability, my lord, has got accepted R2. Lord, your lordship may kindly peruse it for movement of the competent hospital authority as issued.
You will secure the records. See that. What is that documents? Then you have to assess on the basis, because we see that cross-examination and evidence of the petitioner. We see that whether it will affect his 40% to that is cook. What are that injury? How it will affect? Oh, he said he was working as a cook.
No, my lord. Contract.
We will see that evidence, what he has said, how we have cross-examined. Then only we can assess. Yes, we'll secure. Yes. Yes. No, doctor said 40% it will affect your avocation. To discard, what is your cross-examination? You have elicited anything? Then what is his avocation? How he has given a submission, this thing in the claim petition as in a PW1, he has given evidence. Then his evidence, what he has stated, how he was cross-examined. Then I can come to the conclusion it will affect 40% or some extent. Yes, office is directed to secure original records. Yes, yes. Notice to R1 is dispensed. Office is directed to secure original records from the criminal. Yes. Yes, sir.
Number 27, Government Advocate for Appellate. Yappa, Ajeshekar.
Yes. Yes. Where is other side? On what ground you are challenging him? Prakash has come. How much it is awarded? You deposit 50%. Yes. Or delay of 59 days in filing an appeal is controlled. Year 2 of 2020 is allowed. Out on year 1 of 2020 for the reason stated in the accompanying affidavit. IA is allowed. Judgment and award dated 7th September 2019 passed by MESCT Bangalore is in MESC 2462 of 2019 is state subject to condition. Appellant has to deposit 50% of the award amount with interest before this court within 4 weeks from today.
Number 40, Girish V. Baladare for Appellant, matter, M. Sriram, K. Srinivasa, Jagadish. 40.2.
ಯಾರಿಗೆ ಆಯ್ತು ಅವರಲ್ಲಿ ಶ್ರೀರಾಮ್ ಇಲ್ವಾ? ವಾಟ್ ಇಸ್ ದಟ್? Why? What is that? On what ground you are challenging him? Permit ilva? You are appearing for that owner. Then pay and recovery. Yeah, yes. What he said. ಅವ್ರು ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರಲ್ಲ ಇವ್ರು ಸ್ವಾಮಿ ಏನ್ ಹೇಳಿದ್ರು ಸಿಕ್ಕಿದ್ರು ಅವರು? No, that one case Ravi Shankar is appearing. There are different councils. Yes, Mr. Ravi Shankar. Nobody is representing now. In 40.2 early, which respondent, Mr. Jagdish HT is undertaken to appear for Respondent number 2. Office is directed to show his name. Release this matter next week. Barley, 3 jana ಬರ್ಬೇಕು. You can't. I thought that only one single council for all connected matters. 3 different council.
Yes. 44, Nagaraja K for appellant.
IFA for the appellant KSRTC. This appeal is filed by the KSRTC.
Yes.
Only on the ground of quantum of compensation being excessive.
Yes.
May I take your lordship's kind attention to the quantum of compensation awarded and shown at synopsis, my lord?
Yes.
My lord, he sustained fracture of mid shaft of left tibia and fibula. The tribunal awarded compensation of 50,000 medical pain and suffering, 92,400 medical expenses, conveyance for 2 days.
Now, Billy, you are appearing for whom? No, he is appearing for
Yes, sir. Liability against yes, sir.
your formal party.
Our formal party also.
Yes, yes.
For 2 days, conveyance diet to 20,000 ರೂಪಾಯಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಸುಮ್ಮನೆ.
Yes.
ಆಮೇಲೆ ಫಾರ್ 2 days ಅಟೆಂಡೆಂಟ್ ಟು ನರಿಶ್ಮೆಂಟ್ 20,000 ರೂಪಾಯಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಸುಮ್ಮನೆ. ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಫಾರ್ ರಿಮೂವಲ್ ಆಫ್ ಇಂಪ್ಲಾಂಟ್ಸ್ 40,000 ರೂಪಾಯಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಸುಮ್ಮನೆ. ಲಾಸ್ ಆಫ್ ಇನ್ಕಮ್ ಅಟ್ ದ ರೇಟ್ ಆಫ್ 9,000 rupees 3 ತಿಂಗಳಿಗೆ 27,000. ಆಮೇಲೆ 13% ತಗೊಂಡಿದ್ದಾರೆ. 13% ಬರೋದಿಲ್ಲ, 12% ಬರ್ತದೆ. 9,500 ತಗೊಂಡ್ಬಿಟ್ರು ಅಲ್ಲಿ ಕಡಿಮೆ ಆಗ್ತದೆ ಸುಮ್ಮನೆ. ಇದು ಲಾಸ್ ಆಫ್ ಫ್ಯೂಚರ್ ಇನ್ಕಮ್ ಅವ್ರಿಗೆ ಕೊಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ. ಯಾಕಂತ ಹೇಳಿದ್ರೆ ಹಿ ವಾಸ್ ಆಸ್ ಆನ್ ಇದು ಕಾಂಟ್ರಾಕ್ಟ್ ಮೇಲೆ ಬೇಸಿಸ್ ಮೇಲೆ ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ರು ಬೆಮೆಲ್ ಅಲ್ಲಿ.
ಇದು ಎವಿಡೆನ್ಸ್ ಇದೆಯಾ ನಿಮ್ಗೆ ಕೊಡಿ. PW1 ಎವಿಡೆನ್ಸ್ ಕೊಡಿ. PW1.
ಅದು ಕ್ಲೈಮ್ ಪೆಟಿಷನ್ ಟೈಪ್ ಏನೇ ಹಾಕಿದ್ದಾರೆ. ಕ್ಲೈಮ್ ಪೆಟಿಷನ್ ಯಾವ ತರ ಮಾದರಿ ಇದೆಯೋ ಅದೇ ತರನೇ ಹಾಕಿದ್ದಾರೆ ಸುಮ್ಮನೆ ಎವಿಡೆನ್ಸ್ PW1.
Yes, we'll see that. Yes, yes.
And now, my lord, I take your lordships to page 2 of the page 2. Serial number 4, occupation and the person of the person injured, contract worker, operator, name of the employer, BEML Limited, Machine Shop 1, EM Division, KGF Complex, Bemel Nagar Post KGF, income 10,000 rupees. He has not produced a salary certificate, my lord.
And he is not saying that he is the employee. Therefore, I am asking. Yena contract ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಿದ್ರು ಅಂತ. Therefore, I will see that evidence what he has stated.
Yes, yes.
Further said, I am working out my livelihood by doing a contract work at BML. Yes, he is a contractor and he is not an employee.
Well, contract
work, piece work ಅಲ್ಲಿ ಅಲ್ಲಿ ಮಾಡ್ತಾ ಇದ್ದೆ ಅಂತ. While he was returning from
ಅಲ್ಲ ಅದು ಹೇಳಿಲ್ಲ ಅವರು, ಡೀಟೇಲ್ ಆಗಿ ಹೇಳಿಲ್ಲ ಅದನ್ನ. ಪೀಸ್ ವರ್ಕ್ ಅಲ್ಲಿ ನಾನು ಮಾಡ್ತಾ ಇದ್ದೆ ಅಂತ ಹೇಳಿ.
ಪೀಸ್ ವರ್ಕ್ ಅಲ್ಲ.
Operator.
Further swear that I am working out my livelihood by doing contract work at so and so. Contract work so and so ಅಂತಂದ್ರೆ is it an employee?
ಬೆಮೆಲ್ ನಲ್ಲಿ ಅವರು ಎಂಪ್ಲಾಯಿ ಅಂತ ಇವರು ಹೇಳ್ಕೊಂಡಿದ್ದಾರೆ.
I was passing near so and so, driver of so and so vehicle is rash and negligent manner, wrong by doing without the regulations. They are dashed against the said so and so. I swear my life leg is fixed with the rods and so and so. Further swear that 2 years so and so. Vehicle owned dream so and so is damaged. That accident I spent.
ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿರೋದ್ರಿಂದ ನಾನು ಆ ಕೆಲಸನೇ ಬಿಟ್ಬಿಟ್ಟಿದ್ದೀನಿ ಅಂತ ಹೇಳಿ ಎಲ್ಲೂ ಹೇಳ್ತಾ ಇಲ್ಲ ಸುಮ್ಮನೆ.
ಅಲ್ಲ ಅದು ಈ ಕೆಲಸಕ್ಕೆ ಸೇರಿದ್ರೆ ತಾನೇ ಬಿಡೋದು.
ಅಲ್ಲ, ಆಪರೇಟರ್ ಆನ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಬೇಸಿಸ್, ವರ್ಕಿಂಗ್ ಆಸ್ ಆಪರೇಟರ್ ಆನ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಬೇಸಿಸ್.
ಕಾಂಟ್ರಾಕ್ಟ್ ವರ್ಕರ್
ಅವರ
what was his mistake? What were you doing? What contract work mistake? That we have to say. There due to the accident I spent so and so.
ಇಷ್ಟು ಡಿಸೆಬಿಲಿಟಿಗೆ ಯಾರೂನು ಮನೇಲಿ ಕೂತ್ಕೊಳ್ಳೋದಿಲ್ಲ ಸುಮ್ಮನೆ.
And also suffered in a mental pain and no, yes, he's the tribunal has not granted that entire loss cost to him as an 100% disability.
ಅಲ್ಲ ಅಂದ್ರೆ ಎಲ್ಲ ರೆಡ್ಯೂಸ್ ಆಗಿತ್ತು ಅಂತ ಹೇಳಿದ್ರೆ ಐ ಕ್ಯಾನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ಆಮೇಲೆ ಟೆಂಪರರಿ ಎಂಪ್ಲಾಯಿ ಬೇರೆ, ಕಾಂಟ್ರಾಕ್ಟ್ ವರ್ಕ್ ಬೇರೆ. ಕಾಂಟ್ರಾಕ್ಟ್ ಅಂತ ಹೇಳಿದ್ರೆ ಇಷ್ಟು ವರ್ಷಕ್ಕೆ ಅಂತ ಹೇಳಿ ಇರುತ್ತೆ. ಅದು ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಏನೊಂದು ಹೇಳಿಲ್ಲ ಸುಮ್ಮನೆ.
See, it is not that 100% disability has been assessed and he has paid.
Yes, madam. ಅದಕ್ಕೇನೆ ಅವರಲ್ಲಿ ಕಂಟಿನ್ಯೂ ಆಗಿದಾರೋ
pain and suffering so on so transport every week fracture like so on so.
ಆಮೇಲೆ ಇವರು ಲಾಸ್ಟ್ 2 ದಿವಸಕ್ಕೆ ಇಷ್ಟೊಂದು ಕಾಂಪನ್ಸೇಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸುಮ್ಮನೆ.
ಬರ್ತೀನಿ. You have not cross-examined into anything. Have you seen your cross-examination? You have not even your suggestion for that is salary. Then you have to take 10,000 rupees that you have not denied.
ಅಲ್ಲ ಅವ್ರು ಏನು ಹೇಳಿಲ್ಲ, ಅವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ. ನಾನು ವಿಧಾನಸೌಧ
ಆಯ್ತ್ರಿ, ಅವರು 10,000 ಇನ್ಕಮ್ ಇದೆ, ಕಾಂಟ್ರಾಕ್ಟ್ ವರ್ಕರ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಸಿ ಯುವರ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್, ಎಂಟೈರ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಇಸ್ ನೆಗ್ಲಿಜೆನ್ಸ್. That part is not disputed.
One moment, if my lord excuses me, I put in ಇದು ವಿಧಾನಸೌಧ ನಂದು ಅಂತಂದೇಳಿ ನಾನು ಹೇಳಿದ್ರೆ ಅದನ್ನ ಪ್ರೂವ್ ಮಾಡ್ಬೇಕಾಗತ್ತೆ ಸರ್. ನಂದು ಹೌದು, ಟೈಟಲ್ ಡೀಡ್ ಇದೆ ಅಂತ ಹೇಳಿ. ಇವ್ರು ಅವ್ರ ಹತ್ರ ಎಷ್ಟು ಇನ್ಕಮ್ ಇತ್ತು, ಎಷ್ಟು ದುಡಿತಾ ಇದ್ರು ಅಂತ ಹೇಳಿ.
See, time and again Supreme Court said that, see, you can't compare. This is a beneficial legislation, mister.
ಅಲ್ಲ, ಬೆನಿಫಿಷಿಯಲ್
you can't claim that police to produce the documents. Can you produce? Supreme Court said you can't insist.
ಅಲ್ಲ, ಬೆನಿಫಿಷಿಯಲ್
how can you produce? You can't compare this to that other evidence, mister.
ಅಲ್ಲ, ಬೆನಿಫಿಷಿಯಲ್ ಲೆಜಿಸ್ಲೇಷನ್ ಅಂದಾಕ್ಷಣಕ್ಕೆ ಅವ್ರು ಹೇಳಿದ್ದೆಲ್ಲ ಅದನ್ನು
ಹೌದೌದು. Unless you rebutted by that cross examination, you have to accept, mister. How can that you see? No, nothing has been stated in that this thing. Yes.
He was.
Yes, what are you doing, mister? Yen contractor kelsa andre yen, what is this? What is that contract work, mister? Contract work andre? You have to say, mister, what is that work he is doing? Has he employed contract employee working there, or he is doing some contract work? That is not clear. Yes, you see that in that FIR also. Nanu by the so and so factory alli kelasa mugisikondu. That means to show that you are working there as a contract employee. That is not clear. That is what he is saying. Yeah. Yes, you just to whether he is doing some contract work or he is a contract employee. Ali nim case nadisidaru hosa lawyer. The way in which he has filed a chief examination affidavit, we can make out. Claim petition in one page extract made hakitare. He has not stated anything, mister. You verify whether he is a contract employee or he is doing any contract. It is not clear. When will you next week? Yes. If he is a contract employee, then whether you have continued there or you have been not working, all that we have to be established by evidence and this. What do you want?
2 days ಮಾತ್ರನೇ ವರ್ಕ್ ಇದು ಇನ್ಪೇಷಂಟ್ ಇದ್ರು ಸುಮ್ಮಿ ಅಷ್ಟಕ್ಕೆ
I will see that. Yes, at the request of counsel for the respondent, release this matter first week of December.
Number 45, Kamala DK for appellant.
My lord, on behalf of appellant, my lord, I pray for time. Somebody has passed away in their family, it seems, my lord. Kindly have it, call for records, kindly have it next week, my lord.
Office is directed to secure original records from the tribunal.
Number 48, Prakash MH for appellant. O Mahesh.
Yes, Mr. Mahesh, what is this?
Number 48.
Yes, Mr. Mahesh. Nodi Mahesh.
Serial number 48, Prakash MH for appellant, O Mahesh. Serial number 48, O Mahesh.
Also. Yes.
Number 64, SBI Development for appellant. Kumar NR.
Yes, where is Agde? Next week. Yes, next week. You collect from him. Yes. At the request of the parties, release this matter next week. Office is directed to delete the name of M. Narayanappa for appellant. Yes.
Number 65, O Mahesh for appellant, connected matter. Suresham Lathor.
I am for the appellant, my lord, in connected matter. I am ready for our. I am ready, my lord.
Where is Mahesh? Next week.
Yes, my lord.
Yes, none appear for the appellant in MFA 5500 of 2012. Release this matter of 2 weeks. Yes.
Number 68, Suresham Lathor for appellant. connected
Yes, I
matter.
am the appellant, my lord.
Again, the same opponent.
Yes, my lord.
Next week.
Yes, my lord.
Yes, release this matter next week.
Second time passport matter. Serial number 48, Prakash MH for appellant. O Mahesh.
Yes, madam, what is this?
Respondent.
Mahesh is there. Yes, Mr. Mahesh.
ನಮಗೆ ಯಾವ್ದು ಬೇಕಾ ಕೇಸಿ ಬರ್ತಾ
Yes. Yes, madam, what is your case? No, that which is that MEC? 127 of 2018. Yes, which is that paragraph? (127) para 13. Yes, what is the date of the accident? 2018. What was that income? How much he was earning? You have claimed 15,000. Tribunal has taken 8,000. 2018. 12,500. What is the disability? Where is that discussion? 20% the tribunal has rightly taken. There is no dispute regarding the disability. Is it not? The evidence are fully corroborated with the hospital records. There is no reason for me to disbelieve the evidence. So we safely do that injuries sustained RTA petitioner become disabled for permanent disability to the extent of her whole body. This disability would be affecting his monthly income. And so, why future prospects? Huh? What is that? This thing? Carefully scrutinize then the oral evidence between hospital records. 127 alva. Para 14, you read para 14.
It remains that PWD has assessed permanent disability of management and by following reasons in the form of PWD has assessed the shoulder and he has assessed the physical disability of the left lower. The evidence speaks that the register had a lot of muscle strength. He has restriction to his left lower limb. Medical evidence, the practitioner was suffering from physical disability to the extent of the left upper limb, left shoulder, and 16.24%. The thing is, the practitioner is suffering from physical disability left lower limb and 16% on his whole body. PWD has taken 1/3 of
no, madam, if you are claiming that future prospects, is it your case is that you are an employee, you are working? Where is that document to show that you have been removed from the service? Where is that?
Continued.
Yes, you are not even entitled for that future loss of income. Now you are claiming that future prospects. Where is that? See, I have carefully scrutinizing evidence of is a bank statement, appointment letter. All these documents are sufficient to show that his average income is 8,000, 21 years. How can he grant that for any future loss when you are continuing? No records, no finding that you have removed from the service, you are not continuing. Where is that evidence, madam? It is there. Have you read that this thing? Then you are not entitled for even for that also. That has then compensation has to be reduced.
If it is admitted, my lord, we may file cross objections.
Yes, they have not filed cross objection. You think whether you have to prosecute this case or withdraw that? Yes, you verify that. Still, there is a time for filing a cross objection. Yeah. Yes. The request of counsel for the appellant release this matter for 2 weeks. Yes, Mr. Ragda, what is that matter? He is a pillion raider. Now that matter has been referred to that larger bench. Supreme Court ali no extra loading scooter le anta bartadri. Scooter extra loading anta bartade. That it is additional amount is not for that coverage. It is an basic coverage itself is including that. How much? 40,000. No, instead of deciding that question, we can put. No, you are. He is also said you are not there. He is in that legs. Then it is urgent. Yes. Aurena papers illa anta avratra. You don't know what is this. Right, next week. Yes. Yes, yes.